So the affidavit I filed yesterday, can it be called?
Yes.
May it please your lordship, a pending matter for listing of pending matter, your lordship.
Enter in the registry.
May I please, your lordship? Lordship, with the consent of the other side, your lordship, I beg to mention item number 52, your lordship. In this case, your lordship, we are directed to file affidavit in opposition. We have sent it for vetting, your lordship. So maybe come up after 3 weeks.
Item 52.
52.
May I please your lordship? Lordship, I am for the petitioner in this matter. There is an interim order in both the IA and the WPC. Your lordship may kindly continue those.
Mr. R. Boro Learned Counsel appearing for the respond number
6, your lordship.
6.
Or,
Submit that
no, your lordship. For accountant general, this
For the-
brief is the
Office of Accountant General ANE Assam submits that counter affidavit in this counter affidavit on behalf of his client has already been prepared and the same has been sent for vetting. Therefore, full stop there. Therefore, he prays for 2 weeks' time to bring the same on record. Since the prayer is made with the consent of the learned counsel for the petitioner stroke applicant, the same stands allowed. Let the matter be listed again after 2 weeks. Interim orders passed earlier to continue.
highly obliged, your
Free
lordship.
of leisure, lordship.
My lord, I beg to mention item number 18, my lord. This matter will be passed over for the day, my lord.
18.
Yes,
Passed over for the day. On the prayer of Ms. S. P. Chaudhary and the counsel for the petitioner, admission hearing of this matter stands, passed over. For the day. Admission hearing now. Yes.
May it please your lordship, with the consent of the other side, I beg to mention item number 53, my lord. We have given an adjournment letter yesterday, my lord. With the consent, my lord. My lord, due to some difficulty of the arguing counsel, my lord, may let the matter be come after 2 weeks, my lord.
On the prayer of Mr. S. P. Sharma, learned counsel for the respondent.
For a big state when possibly council is coming to Delhi.
Delhi, yes.
Big state.
You are appearing for the state.
Minor.
And counsel for the respondent made with the consent of the other side. This matter stands adjourned for 2 weeks. On the request of Mr. D. E. Majumdar, learned senior additional AG for the state of Assam. This matter is directed to be listed again on 17th of
17th of
June 2025 as a fixed time.
My lord, there is an interim order that means.
Interim order passed earlier to continue till then.
Much obliged.
May it please your lordship, with due consent of the other side, I beg to
Sharma,
mention
could you-
item number
1 minute. Opposite party, huh? I8. Opposite party stroke petitioner. Whatever.
with the consent of the other side, I beg to mention item number 32 of today's list, lordship.
Item
That
number
matter
30
may be 30. Matter may
Yes.
be taken up after 2 weeks, lordship.
on the prayer of learned counsel for the petitioner, this matter stands adjourned for.
Okay.
May I please, I beg to mention item number 31, my lord. Kindly matter will pass over for that 10 days.
Prayer of learned counsel for the petitioner, this matter stands adjourned for 2 weeks, list accordingly.
May it please your lordship. Lordship, I'm praying for listing of a pending matter, lordship. Obliged, your lordship.
May it please your lordship. Lordship, I beg to mention item number 8, lordship.
Hmm.
Your lordship may kindly adjourn the matter for the day and kindly allow it to come up next week.
On the prayer of Ms. V. Shohei, learned counsel for the petitioner, this matter stands passed over for the day.
Deeply obliged.
May I please your lordship? Lordship, beg to mention item number 7. There we have received some instructions.
Hmm.
So we have to clarify. Let the matter be taken up on Monday, your lordship.
Monday. Passed over for the day.
Pass over the day.
There's an interim order, my lord.
Mr. R. R. Gogol and SC Forest Department Assam submits that he has received some instruction. Therefore, this matter be taken up again in the next week. The prayer is not opposed by Mr. S. Burnick, learned counsel for the petitioner. In view of the above, office to list this case for motion again in the next week. Interim order passed earlier to continue.
Obliged, lordship.
May I please, Lordship? Lordship, I beg to mention item number 28 and 30.
Item
The-
number,
At 28 and 30. The matters become infrastructure, so we won't be pricing.
okay. Your name, please?
Um,
You are appearing in this case.
R. Sahana,
What about 29?
28 and 30.
No, 29 is also connected, tagged with it.
So, mainly ours is 28 and 30, 28 and 30.
But there is another matter. You wait. When the matter is called up, we'll pass an order. You wait.
Obliged.
Yes.
It will already be amended Costa del Fine, my lord.
Where is the order? Which page is the order of the court?
No, no. No. Order of this court,
Yes.
as annexure page number 24. In this one, I have already received the pension amount, but my area is late. Pension is over, pension they have given me.
So who is responsible for this, for release of your?
As per, as per previous order, Lanet Council for the Air Authority told before this court that Director General of Civil Aviation, Calcutta, at his table, the file is kept pending. As per previous order.
Mr. PCR made in a counsel for the petitioner. Where is the statements made in the petition alleging willful disobedience of the judgment and order dated 25/4/2023, passed by this court in WPC number 675/2021. The instant petition has been filed. Mr. Mehdi submits that his client has already received the pension. However, the arrear pensionary dues have not yet been paid. First up, having regard to the allegation made in the petition, this court is inclined to issue notice upon the respond numbers 2, 3, 4, and 5 only at this stage. Issue notice returnable in 6 weeks, since Mr. R. Dubey, Learned Counsel, has already appeared for respond number 2. No formal notice is required to be sent to the said respondent. Petitioner to take steps for service of notice upon respond numbers 3, 4, and 5. Question of issuance of notice upon the remaining respondents shall be considered at an appropriate stage as and when the occasion arises. Registry to list this matter again by reflecting the name of Mr. R. Dubey, Learned Counsel for the respond number 2 in the court list.
Yes, ma'am. Yes, I will. 6 weeks.
May I please, Your Lordship? My lord, non-compliance of order, my lord. Order annexure B, page 11, judgment and order, my lord. 11 portion at page 20.
Mr. J.M.H. Chaudhary, Learned Counsel for the petitioner, peruse the statements made in the contempt petition alleging willful disobedience of the judgment and order dated 12/11/2024, passed in WPC number 5511 of 2021. This petition has been filed. Mr. Issue notice returnable in 8 weeks. Petitioner takes steps for service of notice upon the respondents by registered post.
Amlagiri.
Yes, what has happened? 23/10,
Your Lordship,
October 23.
Your Lordship, I've just produced the instructions. If you police here, only would.
No, but have you communicated the orders?
Your Lordship, that it has been communicated, I believe, because
You believe, he doesn't believe.
Your Lordship, that is what they have stated that
He disbelieves you. What to do?
they have stated that they have actually received it. He has received it.
Where is the proof of communication? Have you received the orders?
So far I am concerned, matter, there is no instruction as such. If he has received any.
But if I may state one thing, Your Lordship, if I may state just one particular fact, all this ground of review as such has not been taken up anywhere in the writ petition. Now, if at all if he is aggrieved by this, he has to file a fresh writ petition and challenge this latest revision order, because what I can see, the last review was done on 15/8.
No, if the order of review was not communicated to him, this will amount to no review. We'll lay down that law.
Your Lordship,
We'll lay down that law, I'll tell you the date. We'll lay it down on 5th of June. You file your affidavit, within 7 days, he'll file reply. Non-communicated orders are of no value. Merely,
Lordship.
you can do anything. After 6 months, you can give a back date and say that we have reviewed.
I completely agree, but that ground
is
has
not-
not been taken this writ petition at
No
all.
only money, it is
The
legal
ground
for
of
the-
review.
Is the court powerless to look into those grounds?
Yeah, I'm not saying that,
Then
your lordship.
What is the difficulty? The Supreme Court has laid down the law, the High Court has laid down. Why don't you comply with it? You are only to review the order of suspension and extend it with the reasoned order. Instead of doing it, you are keeping matters pending.
Lordship,
When there is a direction to reinstate, you are not complying with it. What is
Lordship,
happening?
only thing that is actually preventing us right now is
Hmm.
that the whole case records have now been transferred. I've placed that particular letter also.
Hmm.
The whole disciplinary case proceedings, everything has been transferred to the DLR.
Hmm.
Now everything will be now looked after by the DLR. That is what I've been told. And that is specifically, I placed one particular order, letter from the DC to the DLR, assistant DLR, regarding transfer of this whole case. So now this review as such has to be done, as I've been told, instructed by the DC. That now this review has to be done by the DLR because of certain form regularity, it is there in the record, in the particular letter.
After 3 years, my lord, suspension will be 2023, now 25. And
We'll list this matter on 5th of take down heard Mr. R.P. Sharma, learned senior counsel, listed by Ms. So-and-so, learned counsel for the petitioner. Also heard Mr. J. Henrik, learned standing counsel for the Revenue Department, Assam, appearing for respond number. Respond number 2 and Mr. D. Bora, learned G. Assam, appearing. for
1,
the
3, and 4.
Respond numbers 1, 3, and 4. Full stop. By failing this writ petition, the petitioner has assailed his suspension. Made wide order dated 01/10/2023.
23. 1/10/2020, he was suspended.
1/10/2023. You take your seat. I will dictate the order. Pursuant to his arrest in connection with SEB PS case number 73/2023. Full stop. During the course of arguments, Mr. Sharma, learned senior counsel for the petitioner, has argued that although the order of suspension of the petitioner has been continued till today, there has been no review of the same, extending the order with due intimation to the petitioner. Full stop. Taking note of such submission of Mr. Sharma, this court had asked the learned departmental counsel to obtain instruction. Today, when the matter is called up, Mr. D. Bora has produced a copy of the written instruction dated 22/5/2025, issued by the Additional District Commissioner, bracket REV, bracket close, Lakhimpur, which goes to show that order of suspension of the petitioner was reviewed on 14/5/2024 and again on 15/8/2024. Full stop. However, the written instruction is silent as to whether the same was communicated to the petitioner, formally communicated to the petitioner. Full stop. An order of extension of suspension. No, you're right, lady. Whether an order of extension of order of suspension, even if carried out within the period of 90 days, but without communication to the delinquent official, would be valid in the eye of law, and therefore valid in the eye of law is a matter which would call for determination by this court. However, before embarking on an exercise to adjudicate upon the issues raised in the writ petition, this court is of the opinion that the respondents must be directed to file affidavit. This is more so since Mr. D. Bora, learned G. Assam, has submitted that the records have since been transmitted to the Director of Land Records, and therefore action, if any, in the matter is now required to be taken by the DLR. Full stop. Having taken note of the facts and circumstances of the case, this court is of the opinion that the matter would require further examination. As such, issue notice returnable on 9th of June. We'll give you a little longer, 9th of June 2025. Since the respondents are already represented, no formal notice is required to be sent in this case. Extra copies of the writ petition requisite in numbers be furnished to the learned department counsel so as to enable them to obtain instruction and file affidavit. The affidavit on behalf of the respondents shall positively be brought on record on or before 4th of June 2025 by serving advance copy upon the petitioner's counsel. The writ petition will be taken up for disposal at the admission stage. Full stop. If the respondents fail to file affidavit, it is made clear that if the respondents fail to file their counter affidavit on or before the next date fixed, the writ petition shall be taken up for disposal on the basis of materials available on record. Copy of the communication dated 22/5/2025 be retained in the record of this case. Yes,
My lord,
My lord, that DLR is not a mandate party.
you are appearing for whom?
For
Revenue.
commissioners of revenue. Only commissioner.
File it.
my
They
lord,
don't know the DLR, you
Yes.
file it.
my lord, DLR, we filed one Gamburas appeal married 2024 March. It is pending. We moved the High Court, gave 2 months time. Till date, no time. DLR, if it's sent to DLR, is dead, my lord.
File your affidavit.
Of
There's
the-
no point. Yes. Yes,
Malad,
you are absent on the last date.
Malad, he has been Malad got selected,
Hmm.
but because of Malad mismatching of the Malad biometrics, Malad, the biometric has been sent to the Malad FSL.
Yes,
But-
notice have to go, Lordship, and
Will issue notice that
Malad,
Part Mr. M. Mandal and counsel for the petitioner praise the awareness made in the writ petition. The petitioner herein had participated in the recruitment process initiated by the authorities for recruitment of Constable GD in Central Armed Forces, bracket CAFS, bracket close. According to the petitioner, he was selected in the recruitment, in the selection process. Now, he emerged successful in the selection process, full stop. However, due to alleged mismatch of his biometrics, no order of appointment has been issued to the petitioner till date. Hence this writ petition. Full stop. Mrs. Borua, Lanet CBC, appearing for the respondent's place for 3 weeks' time to obtain instruction and file affidavit. Issue notice of motion returnable on 18th of June 2025. Since Ms. Borua has appeared and accepted notice for all the respondents. No formal notice, extra copies. List again on 18th of June 2025 as a fixed item. An attempt will be made to dispose of the writ petition at the stage of admission hearing. The respondents' counsel to come prepared accordingly.
obliged.
Your lordship, my lord, today fixed for instruction, my lord. And matter pertains to, my lord, the pension, my lord. As per the
Is
Sanjita Das
is
and,
it covered under Sanjita Roy's case?
yes, my lord.
Yes? Your sound is very low. Yes or no? Bigger sound. You are, yes. Yes, Mr. Nayak.
As the direction was issued to the irrigation department to obtain instruction, Lordship. That is why I'm looking for the standing council, Lordship. See, it's not present.
Standing Council of
Irrigation department.
difficult.
Lordship will take up
Any,
this. matter
any
after some-
possibility of,
Yes, after some time, Lordship.
then
Yes,
we,
about.
Maybe.
yes. Relaxation of rules.
Yes, madam.
Why? You can't consider his case?
They have filed a affidavit, madam, yesterday, madam. But will come up, pick up the, madam.
You want to file rejoinder?
No, my lord. They have just annexed the last speaking order. I can.
So they are not willing to consider your
Yes, no,
case.
they are not willing to.
Therefore, this has to be decided. We'll issue notice and fix it for admission, short date, decide it.
Till then, my lord, I may be allowed to participate. And my documents may be kept on still covered, my lord.
To participate is not possible. One post will be kept vacant.
Yes, my lord.
How many posts?
65.
One post will be kept
Yes, my
vacant.
lord.
Yes? Yes or no?
No, only that, no, lordship in my.
No. then we'll stay the entire recruitment process.
One-
He has come with a grievance, the court will have to examine it. If he succeeds, then what relief he'll get? You have to be reasonable.
Lordship, here, our order, your Lordship, lot shorten may be given, we'll file a parawise affidavit also.
Let them.
You already filed affidavit.
No, Lordship, it is not affidavit, it is only we are being asked to place the record, Lordship. Order, last order.
Achha, what is there in the last order?
Lordship, in the, actually, what had happened, Lordship, in the earlier first order, Lordship, while passing the order, we erroneously, due to inadvertent mistake, we have not considered the Assam fees, that is a service rule, Lordship. So in the next order, due to inadvertent, we have, after considering this order, this service rule and rule 25, we have rejected this prayer, Lordship.
Both the orders are same, my lord. Here, what they have done, they have just put it,
So your prayer for relaxation has been rejected,
rejected, my lord.
correct?
Yes,
Lordship.
So is this order under challenge?
No,
No, my lord. That's why, my lord, that was asked on last day, my lord. But you may see the last order, my lord. The honorable court has made a, my lord, said that, my lord, they cannot pass one after another order. And, my lord, this is my second round of litigation, my lord. My lord, they will modify every
No.
time, my lord. I have challenged every time, my lord.
Please take your seat. Let him argue his case. He has come to the court. Mr. Das,
My lord.
don't be emotional.
No, no.
If you are, it will be of no use.
Yes, my lord.
Your client is overaged.
Overage.
He wants to participate in a selection
Yes, my lord.
process. He wants condonation or relaxation of his age. That is a matter exclusively in the domain of the executive. And
lord.
here it is the governor,
My lord.
right? They have already examined your case as per the court order and have rejected it.
Rejected, my lord.
So only question is the rejection done in an arbitrary manner
Yes,
and
ma'am.
with a malafide intent?
Yes, my lord.
Otherwise, the court will not do
No,
anything.
my lord. Yes, my lord.
If it is a plausible view, that's the end of the matter. So only 10% chance,
Yes, my lord.
10%,
Yes, my lord.
not even that. You challenge this order,
Yes, I
we'll
shall-
examine
My lord.
and we'll make it clear that the recruitment process will be subject to the final order passed in the writ
Yes,
petition.
my lord.
That's the only order that can be passed,
No, I'll,
right?
no.
So you want to challenge,
Well, I'll challenge, my lord.
How will you
Technically-
challenge?
Technically, I have to challenge this one. Lord.
you have to challenge
Yes,
it
my lord.
because everything else is gone
Yeah,
now.
bad, man.
Only this is
But
what
only
remains.
thing is, my lord, both the orders are same, my lord. Only here, my lord, the new order, my lord, they've quoted the rule of Rule 25.
All
That's
right,
the
whatever it
difference.
is,
I'll
but
challenge this
you
one.
cannot, how will you challenge it? How?
By filing a new repetition,
Filing a,
new repetition, my lord.
correct.
And both the cases will be taken together, my lord.
Then you file it.
I'll file, my lord.
File it on Monday. Can you
I'll
file it?
Monday, my lord.
Then you move it on Monday. We'll grant you unlisted permission. File it on Monday and move it. We'll have it on Monday, this matter.
Fine.
You file, you make a mention in the morning, we'll allow you unlisted.
I'll today, my lord.
Huh?
I'll file it today, my lord. By the course of the day. Oh, do not course of the day, my lord. Everything is ready, my lord. Only this.
On the prayer of Mr. SP, that's the counsel for the petitioner. This writ petition is directed to be posted again for motion on Monday, that is 26/5/2025, so as to enable him to file appropriate proceeding, assailing the order dated 5/5/2025, rejecting the prayer for relaxation of his age. Mr. P. Sharma, Learned Standing Counsel for the Fisheries Department, is present. Mr. T.J. Mahanta, Learned Counsel, assisted by Ms. P. Sharma, is present for the APSC. Ms. U. Sharma, Learned G. Assam, is present for the state. Full stop. List the matter accordingly. In the morning, you make a mention.
On Monday, my lord.
Yes,
It's going to be Monday. I'll file.
make a mention on the Monday morning. We'll allow you.
Obvious.
Highly obliged.
May it please your lordship. My lord, here in this case, my lord, the petitioner was appointed in the year 1993 as a cleaner under the Goalpara Municipal Board. His grievance is that he has been recently, in February 2022, has been released without prior mention, without any, my lord, retirement benefit. My lord, he is claiming that since the government has taken up a policy to give minimum wage, he may be paid minimum wage for the period after completion of 10 years.
We'll issue notice now.
my lord.
Lord Mr. A.R. Sigdal and counsel for the petitioner peruse the averments made in the writ petition. The petitioner is aggrieved due to non-payment of his area salary and retirement benefits, which he claims to be entitled to due to rendering 29 years of service under the Goalpara municipality. Full stop. Mr. D. Bora, Lanet G. Assam, appearing for the state, prays for some time to obtain instruction. NOM 6 weeks. Since Mr. D. Bora has appeared and accepted notice for respondent numbers 1 and 5, no formal notice is required to be sent to the said respondents. Extra copies of the writ petitioner, requisite numbers be furnished to the learned department council. Within a week from today, petitioner to take steps for service of notice upon remaining respondents. Registered post with AD within a week. Yes. Yes.
May I please, your lordship, my lord, here the case, my lord, simultaneously, my lord, criminal proceeding as well as departmental proceeding is going on, my lord, basing on the same subject matter, my lord. So at this stage, my lord, I pray for the stay of the departmental proceeding, my lord. In the similar situation, a person approached before the honorable court, my lord. The honorable court, on the strength of Supreme Court decision, state the departmental proceeding, my lord. If your lordship permit me, my lord, I can supply copy. He is also police.
No,
person.
departmental proceeding was initiated when?
Lordship.
Let us see, where is the order?
Yes, yes. My lord.
1823, 18/9/23, Lordship. Shock was issued,
18/9/2023.
Lordship.
And criminal proceeding?
Proceeding, my lord, charge sheet has been filed recently, my lord, that your lordship will see at page. On 30/12/24 at page 35 to 73. Making, my lord, comparison at page 75 and 35, my lord, it reveals show cause, my lord, out of the same subject matter.
Page 75.
Yes, my lord. Is the show cause.
So this is not a case of any financial embezzlement.
No one.
Lordship.
Yes, let me see, where are other orders?
My lord.
Pass of the order.
Yes, yes, I have given.
Yes, what do you have to say, Ms. Bhattacharya?
Lordship, here only ground in the disciplinary proceedings is the gross misconduct, and because of this, he has been show cause, Lordship. So there is nothing of that what has been, he has been stating,
And
Lordship.
what is the ground, what are the charges against him in the criminal proceeding?
Criminal proceedings,
Same,
Lordship.
my lord, page 70.
Page?
70. 70 and 71. Is a part of the charge sheet.
Lordship,
Or
here it is not
69.
on misconduct, Lordship.
Basing on the criminal case, my lord, page 69 and 70.
This is bribery, Lordship, bribe of 20,000, Lordship.
Mr.
So misconduct part is
Mr.
there not
Borgoya,
in the disciplinary proceedings.
It is not exactly the same charge. The charges are different. There in the departmental proceeding, the charges is of adopting a soft stand. And here the charges of asking for bribe.
No, basing on the same police station case, basing on the same.
File your affidavit, will issue
Lordship.
notice on both main and
Lordship.
interim prayer. When is the next date fixed in the Next date fixed in the departmental proceeding, when is it?
Very shortly, my lord, exact date I do not know, my lord, at this moment.
Actually, you seek adjournment, we'll issue notice on the main as well as the interim prayer.
Yes.
Heard, Mr.
Shortly.
How short? August?
No, my lord.
August is no short. Okay, July. When do you want?
Any day by first week or second week, my lord.
Who is in a hurry, you or your client? Who is in a bigger hurry? Huh? We have to give them some time to respond because
Till then, my lord, no action has to be taken by the department. my lord.
I had Mr. J. Borville and counsel for the writ petitioner. There is the amendments made in the writ petition. By filing this petition, a prayer has been made to stay further proceeding in the departmental proceeding initiated against the petitioner by show cause notice dated 18/9/2023 on the ground that on the same set of allegations, a criminal case is pending against the petitioner, wherein charge sheet has been submitted on 30/12/2024 in connection with, what is the criminal case number? In connection with
Page 25 is the affair.
page 25.
Is the
MR number 35723, Lordship, page 35.
25.
In connection with
SCB 60/23. Page 30.
the proceeding pending before the Court of Special Judge Assam Guwahati in connection with PS SCB case number
60/23.
60/.
This is FIR number,
This
Lord.
is the FIR number
Yes, Lordship.
Charge sheet.
And
What
this
is
is MR number 357, Lord.
in connection with
23.
MR number 357 of 2023.
Yes, Lordship.
Full stop. Ms. M. Bhattacharjee, learned additional senior government advocate Assam, appearing for the state, on the other hand, submits that the allegations in both the proceedings are distinct and different, and therefore she be permitted some time to obtain instruction and file affidavit. In view of the above, issue notice of motion returnable on. We'll have it on 25th June,
Lordship.
25th June, 25th June.
Only till then, my lord.
25th June. Since Ms. Bhattacharjee has accepted notice on behalf of all the respondents, no formal notice is required to be sent this case. Extra copies of the writ petition, requisite in numbers be furnished to the learned G. Assam for obtaining instruction and filing affidavit. Heard on the prayer of interim relief, the said prayer will be considered on the returnable date. Since no definite date is fixed in the departmental proceeding, no definite date to the knowledge of the petitioner is fixed in the departmental proceeding. It will be open for him to seek adjournment before the inquiry officer. Citing pendency of this matter if so advised.
Right, please, my lord. My grievance in this writ petition is that I have been dismissed from service.
You have been?
Dismissed from the service because of the reason that double payment has been made to one of the suppliers to the Assam Cooperative Jute Mills. Now, my lord, in this case, there are two double payment that has been made. One is being 5,12,000. The another 5,12,000 has been made to the jute
Correct.
supplier. My lord, that has been erroneously made. Instead of 5,12,000.
Do you have any objection if we issue notice?
No, I do not have any objection. Deeply obliged, my lord.
Heard Mr. B. Dekal and counsel for the petitioner peruse the amendments made in the writ petition. The present petition has been preferred inter alia being aggrieved by the order dated 01/04/2025 by means of which the petitioner was dismissed from service. Full stop. Mr. G. Bordoloi, learned standing counsel for the Corporation Department, Assam, prays for some time to obtain instruction in the matter. NOM 66, since Mr. Bordoloi.
Lordship, here I appear for aspirant number 1, your lordship. Others, they have to take steps, your lordship.
Why managing director?
Managing Director is Jute. Jute
Access
Meal,
notice for respondent number one, no formal notice is required. to
Assam
send to the
Cooperative
said
Jute Mills,
respondent.
Your Worship.
Extra copy of the writ petition be furnished to Mr. Bordolai. Petitioner takes steps for service of notice upon the remaining respondents by registered post with AD within a week from today. Since it is a case of dismissal from service, this court is of the view that the matter calls for expeditious hearing. The respondents to therefore file affidavit facilitating expeditious disposal of the writ petition.
Obliged.
The petitioner retired from Brahmaputra Valley Fertilizer Corporation as a additional chief engineer. He has submitted a joint option form for a higher pension and demand notice has been issued. Then respondent, EPF and all other have said that it is wrong, miscalculation of the original option paper. And they have not corrected it. This is my case. Reassess the demand notice.
Where is the demand notice page?
It is more than, this is page 30. Page 29 and 30. It is, if I pay this amount, I have to lose 7 lakhs, 6 lakhs, 7 to 8 lakhs. It should be around 11 lakhs, but they paid 18 lakhs. So I could not pay the amount. No time was also given to me, and it was admitted by the corporation, by employer also, employee state prominent fund corporation. This is admitted fact that this miscalculation is there. Both the employer and the employer provident fund has accepted that it is a mismatch due to computer error while uploading this.
No, you have deposited how much?
I have not deposited, my lord.
Ah,
Not deposited. I have approached the authority, employer, to correct it. Then they approached the respondent number 7.
acha. So you say according to you, higher amount is
More than 7 lakhs has been increased. My calculation and my option form is right, my lord.
Yes.
There is nothing, lordship kindly see.
No, Mr. Ahmed, I have not understood. According to you, the amount should be higher.
No, upon demand notice, lower, should be lower, around 11 lakhs. But they have given you 18 lakhs. I have to pay 18 lakhs.
That 18 lakhs is on what account?
For to get pension in higher rate, as per Supreme Court judgment, my lord. Option form is there, then according to if I deposit that, then you will pay the higher amount of pension to me.
So
Reassess the demand.
So notice has to go.
Yes, my lord.
Heard Mr. Ahmed, counsel for the petitioner carries the amendments made in the writ petition. Being aggrieved by the demand letter dated 18/6/2024, the instant writ petition has been filed, inter alia contending that the amount demanded by the impugned letter is higher than what is higher than the amount payable under the law. According to Mr. Ahmed, it is the admitted position of fact that due to a computer error,
Computer error, they have stated in.
an erroneous amount has been demanded for the petitioner, thus, causing serious prejudice to his interest. Full stop. Mr. S.K. Mehdi, learned CGC appearing for the respondent, prays for some time to obtain instruction. Issue notice returnable on
Short date, if not keep.
short date.
Pension
25th June, 25th June. On 25th of June 2025. Since Bidam Medhi has already accepted notice for respondent numbers 1 and 2, no formal notice is required to be sent to said respondents. Extra copies of the writ petition may be furnished to the learned CGC. Petitioner to take steps for service of notice upon respondent numbers 3 to 7 by registered post to AD within 3 days from today. heard on the prayer of interim relief. The said prayer will be considered on the remaining, on the returnable date.
Obliged.
May please, the Lordship. Matter pertains to retirement benefits, Lordship. The in charge Child Development Project Officer of Mohama was appointed the petitioner wife as a Anganwadi worker of Jalabila Anganwadi Central, Lordship. Thereafter, she joined the service on 26/3/2003, and she had been serving continuously till her death. Lordship.
Notice will go. Notice will go now. You are Mr.
MS Mondal.
Oh, one.
Heard Mr. M.S. Mondal and counsel for the petitioner peruse the averments made in the writ petition. The grievance of the petitioner expressed in the writ petition pertains to non-payment of retirement dues which the petitioner claims to be legitimately entitled to under the law. Stuff. Mr. C.K.S. Borua, learned G. Assam prays for some time to obtain instruction in the matter. NOM 6 weeks since Mr. C.K.S. Borua has accepted notice for respond numbers
1, 2, 5
1, 2,
and 5.
and 5, and Mr. S. Bora, the standing counsel for the Women and Child Development Department for respond numbers 3 and 4. Service of notice in this case is deemed to be complete. Extra copies of the writ petition, requisite in numbers, be furnished to the learned departmental counsel so as to enable them to obtain instruction and file affidavit.
Obliged.
This is seeking regulation.
There is already orders, similar orders. Have you got it?
Yes, sir. On 11.
Connected matter, past order.
Notice and we'll have it tagged with the other matters.
sir.
Give a, who is appear? Mr. P. Sharma, standing counsel fisheries for respond numbers.
4, 6, 7, 8.
4, 6, 7, 8.
Time for 3 and 5.
Mr. V.
Veera.
Rajkua for respond number.
3 and 5.
G. Sharma, learned G. Assam for 1. Mr. P. Nayak, learned additional energy finance for respond number 2. So all covered. Serially you can deliver, but ye to order.
Extra copy.
Yeah, so. Dispose of no, yeah.
Obliged. Obliged.
Some
Similar matter last time.
Last time.
Notice may be government.
Mrs. D. Chaudhary and counsel for the petitioner, paid the averments made in the writ petition. Ms. Chaudhary submits that a similar writ petition in the form of WPC number
2662.
2662 of 2025 is pending before this court, where the same issue has been raised. Mr. S.K. Medin and CGC appearing for the respondents has prayed for some time to obtain instruction in the matter. Now in 6 weeks, since Mr. Medhi has accepted notice for all the respondents. No formal notice, extra copies list along with WPC 2662 of 2020.
May I please, my lord. Lord, initially the petitioner, my lord, was.
Are you willing to forego your promotion?
Yes, my lord, I gave an affidavit. My lord, what has happened is this, that petition had been disposed of by asking me to file a representation. I filed the representation, they have rejected it on the ground that I have, since I have already taken it, then therefore my foregoing now does not matter is what they are trying to say. If lordship has the last impugned order, which lordship will find it
See,
page
Mr. Datta,
71.
see, the point is, unless, see, she is the caregiver of people,
Only person.
old people in distress. So she is not the petitioner here. Those people are the petitioner. The court will have this in mind. Because it is not a question of moving her here and there. It is a question of protecting their interest.
Yes.
So unless you can show that something mentioned is not correct, we'll stay our promotion, particularly when she is willing to forego our promotion. These are matters the court has to be sensitive. Even the department has to be sensitive. All we can do is give you time till Tuesday to pass an order on your own. Otherwise, we'll pass the order. Choice is yours. You want the court to pass the order on Tuesday or you want to seek instruction till Tuesday? See, people, old people, elderly people in distress, who are living in the care of somebody in the family, and when the person is willing to forego promotion, according to us, it is not this petitioner who is before the court, but those helpless people who will be in very, very difficult situation.
Yes, my lord.
So you must tell it to your clients.
My lord,
These are only 1 in a million cases, and the organization has to find a way to deal with it. What will happen to these people if they are really surviving on the care of these persons like the petitioner? They will perish. The court has to be sensitive about this. Tuesday or today, that's the only thing we are asking you, nothing else.
My lord, one aspect I would like to submit before you, Lordship, my lord. This aspect has been considered earlier also. In 2024, she approached this honorable court with a specific direction from this honorable court that direction should be given to the respondent authority to retain her in the present place of posting in Guwahati for 12 months.
So no, are you disputing that her mother is suffering from Alzheimer?
Yes, my lord. Yes,
dementia?
yes, yes.
You're disputing?
I- Not
not correct.
disputing, my lord.
Not
It is
disputing.
admitting. But considering all aspect, my lord, he already accept the promotion. And Durgapur is, that is why
All right,
we,
heard Mr. R. Majumdar, learned counsel for the petitioner, peruse the amendments made in the writ petition. The petitioner who is serving as an assistant sub-inspector under the CRPF and is presently posted at Group Center at Guwahati has approached this court assailing the order of promotion dated 31/01/2025 and the consequential transfer to the
232 battalion.
232 bracket M bracket close battalion CRPF located in Durgapur, West Bengal, on the ground that she is the sole caregiver of her aged mother who is suffering from Alzheimer, stroke, dementia, stroke, atrophy of brain, and therefore needs constant care and protection for her survival. Full stop. Mr. Majumdar has submitted that his client is willing to forego the promotion just to remain at Guwahati so as to continue to be the caregiver of her ailing mother. Full stop. The prayer has been resisted by Mr. Datta Lanet CGC on the ground that similar representation filed by the petitioner, a representation submitted by the petitioner on earlier occasion on same ground has been considered and rejected by the authorities. Mr. Datta has, however, admitted in his usual fairness that the respondents are not disputing the claim of the petitioner that she is the sole caregiver of her ailing mother who is suffering from diseases such as Alzheimer, stroke, dementia, stroke, atrophy. Full stop. While dealing with a matter of this nature, this court will have to be conscious about the fact that it is not the petitioner alone who is before the court, but even the ailing person who is in a very vulnerable position. No, you're right. This court has to be conscious about the fact that in this petition, it is not only the petitioner who is before the court, but the ailing person who is voiceless and is unable to approach the court seeking protection of her interest has also to be kept in mind by the court. Full stop. If the petitioner's mother is unable to take care of herself and she is the sole caregiver of her mother who is suffering from such serious diseases, the issue would lie within the domain of Article 21 of the Constitution of India, and therefore the court will have to deal with such matters with extreme sensitivity. Situated thus, I am of the opinion that the matter calls for further examination. Issue notice of motion returnable in 6 weeks. Since Mr. Datta has appeared and accepted notice on behalf of all the respondents, no formal notice is required to be sent at this stage. Extra copies of the writ petition be furnished to Mr. Datta within a week from today. Heard on the prayer of interim relief, having regard to the facts and circumstances of the case, it is hereby directed that status quo as regards the present place of posting of the petitioner at Guwahati be maintained until further orders.
I'm obliged.
Please, my lord.
No, there is one aspect of the matter. A movement order was issued to me on
Consequently, the movement order dated
20th of May.
20th of May 2025 shall remain suspended.
I'm obliged.
Mr. Majumdar, movement order, give a copy. Yes,
Lordship, this matter pertains to family pension of the petitioner, your lordship. The petitioner approached the Central Administrative Tribunal, your lordship. Lordship, you will find the order of disposal
you
from
want
page
the order of CAT to be implemented by the High Court. It will be dismissed ultimately, but now I'll issue notice. You can't do that. CAT has the power to issue contempt proceeding for
No, I think
violation of
that
its
the
own order.
representation also not being entered.
Nothing will happen. Your petition will be dismissed, not today. You can withdraw and approach the CAT. That will be good for your client. Otherwise, just to make you happy, I can issue notice, but it will be dismissed. CAT has the power to implement its own order. You go to the CAT. Why have you come to High Court? If you fail here, then your doors will be closed there also. You want to think about it? We can have it next week. Examine it.
Okay.
Huh?
Next
week. Have you understood what I'm saying?
Yes.
You are complaining that the order of the CAT has not been complied with. So you are in the High Court.
We have complied, your lordship. They have not taken the order, your lordship.
You tell it to the CAT. We'll have it next week. You examine. Okay, on the request.
Next
of-
week, your lordship.
Huh?
Next week.
Next week. Request of Mr. Hazarika, Mr. R.P. Hazarika and any counsel for the writ petitioner that this matter be listed again in the next week for motion. You examine it, and if you are satisfied, otherwise you argue, we'll examine it. But ultimately, this petition will not survive.
The communication.
So it will be, it will not be profitable, beneficial for your client. Unnecessarily, time will be lost. Okay? You check up, there is power of CAT to comply,
Wait,
to
wait,
enforce its own order. Yes.
This is prayer for relaxation of case for applying for a job. Lordship, the last date of application has already been over. When the petitioner tried to apply, that application was not accepted.
Hmm.
So therefore, they have.
But how will the petitioner application? He was already overaged.
Yes, Lordship. My prayer is that
We'll issue notice that there is nothing in your case.
I accept, Lordship.
We'll issue notice.
Yes,
After 1 month, we'll dismiss it. Last date
I'll
is
be
over.
highly obliged.
Huh?
I'll be highly obliged, Lordship.
That is why we want that you should be obliged.
He's also
What
late
to
in
do?
Yes, my lord, notice.
He knows what has
He-
happened.
My lord.
So we have to.
He's also late
We
to
have
come.
to think about him also.
Yes, my lord.
Not Mr. R. Sharma, and counsel for the petition. There will be amendments made in the writ petition. The petitioner is aggrieved due to non-consideration of his request for relaxation of age. Full stop. Mr. Ardhar Lanet, additional senior government advocate Assam submits that the last date for submission of application is already over, and therefore the writ petition has become infructuous. Mr. Dhar, however, prays for some time to seek complete instruction with the matter. NOM 6 weeks. Since Mr. Dhar has appeared and accepted notice for respond numbers,
My lord, 1, 2, 4 and 5, my lord.
1, 2, 4 and 5 and Ms. P.
Oh, 5, my lord. 1, 2 and 5, my lord.
1, 2 and 5 and Ms. P. Sharma for respond numbers
3 and
3 and 4. Service of notice deemed to be complete in this case. Extra copies of the writ petition. There is a similar order. Where is that order?
My lord, I have annexed, my lord, page, my lord, 128, my lord. Your lordship order, my lord.
Page 128.
Lordship, 129 is the one.
Everything is same department.
Lordship. He's
Huh?
ITBP, my lord, Indian Tibetan Border Police, my lord. His quarter is expired on, my lord, 7th May, my lord.
So, Mr. Ellen Ding, Mr. S.K. Madhi, CGC, you find it the same order? The interim order, 126, page 125, huh? The allotment of quarter made to the petitioner had expired on 7/5/2025. Rest will be the same. He is also posted in Sikkim.
Sikkim.
All right. ITBP Sikkim.
Mass problem.
List along with this. Yes.
Malad, item malad 21, 22 and 23 are malad similar matter, my lord. They are recommended by the DLC, my lord. When, my lord?
It's covered by the judgment of 3/4.
Yes, my lord.
We'll dispose it of.
We'll examine.
Do you have the judgment?
Well, I have annexed, my lord, similar judgment passed by, my lord, page, my lord, 45, my lord. Following that judgment, my lord, this is passed, my lord. Page 45, my lord, and this judgment was quoted page 47. And page 48, paragraph 5, my lord.
Acha, you write here, heard Mr. A. M. Barbuya, learned counsel for the writ petitioner. Also heard Mr. Ardhar, learned additional senior government advocate Assam, appearing for the respond numbers.
My lord, here. SLC, my lord. No, not only SNC. One,
Respondent numbers, I am not asking.
1, 2, 3, 4, and 6.
1, 2, 3, 4, and 6. Mr. P. Nayak, learned additional AG, Packet Finance is present on behalf of the respond number 5. First up. The case of the petitioner for appointment on compassionate ground was recommended by the DLC Hailakandi, but as the matter was pending before the SLC, the Commissioner and Secretary to the Government of Assam Personnel Department had issued the impugned notification dated 18/9/2024, abolishing the scheme, altogether abolishing the scheme. Full stop. Scheme, full stop. As a result of which, the claim of the petitioner got prematurely extinguished. By referring to the judgment and order dated 03/03/2000, is 2023 or 25?
Judgment, my lord.
Yeah, why have you written 2023?
Yes, my lord, I have annexed.
Huh? So much of lethargy in your synopsis, why have you written 3/3/2000?
Sorry, my lord, I have annexed it, my lord.
People are not fit to practice in the High Court.
Page 40
2025, is it?
Page
Is it?
43, my lord, I have. Memorandum, I have annexed.
I am asking you whether the judgment is 3/3/23 or 3/4/25.
25, my lord.
Then why have you written? It's a 3/3/4/2025. What is the last sentence? Passed by a coordinate bench in WPC number 342 of 2025 and the batch of connected writ petition. Mr. Borbia submits that in view of the observations made in paragraphs 9 and 10 of the said judgment, the petitioner's case deserves to be examined and appropriate decision be taken in respect thereof. Mr. Har, learned additional senior government advocate Assam, and Mr. Nayak, learned additional AG, Packet Finance, Packet Pro Assam, have also fairly agreed to the said proposition. First up. By the judgment and order dated 3/4/2025, passed in WPC 342 of 2025, a coordinate bench had disposed of several writ petitions wherein The same office memorandum dated 18/9/2024 was under challenge. Full stop. The operative part of the judgment is contained in paragraphs 9 and 10, which are reproduced herein below. Full stop. Since there is a consensus at the bar that the petitioner's case will be covered by the aforesaid judgment, this writ petition is being disposed of at the stage of motion hearing by providing that the respondents shall consider the case of the petitioner in the light of the observations made in paragraphs 9 and 10 of the judgment and order dated 3/4/2025 and take appropriate decision in the matter as may be permissible under the law. Whatever be the outcome of the process, the same be intimated to the petitioner in writing without undue delay. With the above observation, writ petition stands disposed of. Same order in the next two matters also. Just check. All are DLC.
Yes,
Haila
my
Kandi.
lord. Just background is next in paragraph 4, my lord. In each case, background is written by.
Background is, DLC Haila Kandi, all.
Yes, my lord. Yes, my lord.
And parties are also same.
Parties are same.
Yes. Disposed of.
Apply.
Yes.
It seems covered case law.
Huh? Covered case.
Law.
Right, heard Mr. P.K. Dekal and counsel for the petitioner. Also heard Mr. N. Upadhyay and standing counsel, Irrigation Department, Assam. Then serially you go, huh? We'll go serially. Also heard Mr. N. Upadhyay. and
1, 4 and 5, Lordship.
Standing counsel, Irrigation Department, Assam, appearing for respond numbers 1,
4 and 5.
4 and 5. Mr. P. Nayak, Leonard, additional AG, Bracket Finance, Assam, for respond numbers
2 and 8.
2 and 8. Miss U. Sharma, Leonard, G. Assam, for respond numbers 3. Respond number 3. And Mr. S.K. Medi, Leonard, standing counsel for the office of AG, A&E, Assam, for respond numbers 6 and 7. Full stop. The writ petitioner is the widow of late Prafulla Kumar Roy, who was initially engaged as a master roll worker on 01/04/1988 and was later regularized. Master roll worker under. He was initially engaged as a master roll worker under.
In the irrigation department, my lord.
Master roll worker in the irrigation department and was subsequently
Dubri.
regularized. And his service was subsequently regularized as Chokidar by order dated 6/10/2005, issued by the respond number 5. Full stop. The deceased husband of the petitioner was accordingly allowed to draw pay scale of rupees 2450-40-2490-EB-3490-3670 page paratooth power. Paratooth power. Good stuff. The deceased husband of the petitioner retired from service on attaining the age of superannuation with effect from 28/2/2010. Full stop. Although he was entitled to pension and other retirement benefits, including terminal gratuity, no such benefit was extended to the petitioner, to the petitioner's husband, who ultimately died on 29/11/2023. Full stop. The present writ petition has been filed by the widow of late Prafulla Kumar Roy, seeking a writ of mandamus directing the respondents to pay pension and other retirement, family pension and other retirement benefits to the petitioner, since he had rendered more than 20 years of continuous service under the department. Full stop. Mr. Deka, learned counsel for the petitioner, submits that the claim of the petitioner is covered by the judgment of this court rendered in the case of Sangeeta Roy versus State of Assam and others, and therefore the same be disposed of in the light of the observations recorded in the said judgment. Sangeeta Roy, just see the citation, huh? It is there. Mr. N. Upadhyay, learned Standing Counsel for the Irrigation Department, Mr. P. Nayak, learned Additional AG Finance Assam, Mr. S.K. Medhi, learned CGC, and Ms. U. Sharma, learned GA Assam, have all. Huh? SCAG and A&E, SCAG, and Ms. U. Sharma, learned GA Assam, have all agreed that the case of the petitioner is covered by the judgment of this court rendered in the case of Sangeeta Roy Supra. In view of the above, this writ petition, in view of this above, and considering the consensus evolved at the bar, this writ petition is being disposed of with a direction upon the respondents to examine the claim of the petitioner and thereafter pass appropriate orders therein so as to redress her grievance in the light of the decision rendered in the case of Sangeeta Roy, Supra. The aforesaid exercise be carried out and completed as expeditiously as possible, but not later than 90 days from the date of receipt of a certified copy of this order. Writ petition stands disposed of.
Annexure 8 has to be certified.
Huh?
Annexure 8, my lord.
Writ petition stands disposed of before that. Consequently, annexure
15 November.
Letter dated
15 November 2022.
15
November.
11/2022, by means of which the claim of the petitioner was rejected, stands set aside.
Deeply
Petition
obliged.
stands disposed of.
May it please your lordship. Lordship, this IA has been filed for including the PCCF as respondent number 7 and the accountant general as respondent number 8 also. Earlier incumbent has retired on superannuation.
Copy number 1 and 2 as respondent number 7 and 8.
Lordship, I have mentioned as respondent number 4 and 6. 6 is the principal chief conservator of forest. That may be implemented as 7 and 4 as 8.
No, you want whose implement? Where are these two persons?
Opposite parties number 1 and 2.
1 and 2. They will be implemented as 7 and 8.
7 and 8.
Then, heard Mr. Why? Because earlier incumbents have retired.
Yes, Lord.
Take down. Heard Mr. H. Agarwal, learned counsel appearing for the applicant also. Heard Mr. R. Gogoi, learned counsel for the respondent number. So and Mr. R. K. Talabkar, learned counsel appearing for the respondent number 5. This application has been filed with a prayer to implead the opposite party numbers 1 and 2 as respondent number 6 and 7 and 8 in the connected contempt case on the ground that the earlier incumbents have retired from service and the opposite party numbers 1 and 2 are now responsible for implementation of the court's order. Mr. Gogoi as well as Mr. Talukdar have submitted that they do not have any instruction to file objection opposing the prayer made in the IA. In view of the above and considering the ground on which the prayer is made in the IA, same stands allowed. Consequently, the opposite party numbers 1 and 2 would now stand impleaded as respondent numbers 7 and 8 in the connected contempt case. Applicant to file amended cause title in the connected complaint case. Register to list the matter thereafter for necessary orders. IA stands disposed of.
All of.
One of the matter relates to the claim of the petitioner for pension under the 69 rules. Now, as far as the facts are concerned, at page, my lord, if your lordship would kindly take the repetition for a moment. Page page number 16.
Is appearing for the respondents here?
Yes, Lordship, I'm preparing for the,
Huh?
I'm preparing for the board.
I'm not asking board or respond number,
Respondent number 3 and 4, 2 and 3.
2 and 3.
Government is there on the other side.
What about 1? You are appearing. Yes.
Alter 9.
Why so much of confusion? Yes.
Milord, page 16, on the recommendation of the Assam Public Service Commission, the petitioner was appointed as Assistant Engineer Civil under the then Directorate of Municipal Administration at page 16. On 5th of July, 1988. Consequent upon withdrawal of the appointment of Sri Majibur Rahman Pradhani and on recommendation of the Assam Public Service Commission, while later dated so and so, Governor of Assam is pleased to appoint the following person temporarily to officiate as Assistant Engineer under the Directorate of Municipal Administration in the scale of pay and so and so. Hello, towards the bottom is the name of the petitioner, Muhammad Azizur Rahman. Then, my lord, at page 18, the services of petitioner was placed at the disposal of the Assam Water Supply and Sewerage Board on deputation. Page 18.
Yes.
Then, my lord, at page number 20, if your lordship should kindly come, it is on 25th of July 96. This is important. Let me read this. With reference to your letter, this is a communication by the government to the managing director of the board. With reference to your letter on the quoted subject, I am directed to say that Sri Azizur Rahman, Assistant Engineer, should be absorbed substantively in service of the board, and then the board will appoint him substantively in the board under section 22(2) subclause 2 of the Assam Urban Water Supply and Sewerage Board Act 1985. The service rendered by him in the state government shall have to be treated as service under the board and have enjoyed all rights and privileges, that is leave, pension, etc. in the change situation as he was employed in the state government employment. I am therefore to say that service of Sri Rahman, Assistant Engineer, may be treated accordingly with effect from the date of his joining in the government service, that is 5/7/88. So, my lord, he was absorbed. And formal order of absorption is at page number 21. Pursuant to the letter which I read just now, in pursuance of the government letter and under section 22(2) of the Assam Urban Water and Supply and Sewerage Board Act 1985, services of Sri Azizur Rahman, Assistant Engineer, is hereby absorbed with effect from the date of joining in the government service, that is 5/7/88. Thereafter, he rose to the position of Chief Engineer and he retired. Now the dispute is regarding, my lord, whether I am entitled to, my lord, CPF or I am entitled to regular pensions. Now, if your lordship would kindly come to page number 10, where we have quoted section 22(2)(2), my lord, at page 10.
Yes.
That he should be absorbed substantively in the services of the board, and board will absorb him substantively in service, and thereupon services rendered by him under the state government shall be treated as services under the board, and he shall be entitled to have such right or to such similar right in the change situation with regard to remuneration, leave and pension, as will not be less favorable to the service conditions, agreements, rights, as he would have been entitled before he was employed in the board. So, my lord, his service condition cannot be altered despite the absorption in the board. Now, my lord, I applied for, then, my lord, of course, I was paid CPF and all. in paragraph 17, I have also given an undertaking to return the, my lord, that post 50% of the CPF account. Now, my lord, the authority has rejected my claim. Now, if your lordship kindly takes the affidavit filed by the respondent number 2 and 3, that is both.
Yes.
It starts at page number 44. If your lordship should kindly come to para 5 and 12 of that affidavit. At page 45 is para 5. That with regard to the statements made in paragraph 2 of the writ petition, the answering respondents beg to state that while government notification dated 5/7/88, the petitioner was appointed temporarily to officiate as assistant engineer under the Directorate of Municipal Administration, Assam, Hengrabari. Immediately after his appointment, his service was placed under the disposal of the Assam Urban Water Supply and Sewerage Board on part-time basis. Even at the time, his service was not regularized as assistant engineer under the municipal administration, and he has been deputed to board by notification dated 10/7/89. Accordingly, he joined the board on 3/7/89. Mala, I'll make my submission. Please come to para 12. That with regard to the statements made in paragraph 11 of the writ petition, the answering respondent begs to state that it is not a fact. The terms of section 22(2) of the Act of 1985 is wrongly interpreted by the petitioner, as the petitioner is absorbed under the board and it is undertaking a government undertaking, hence there is no provision for government pension to the employees of the board. Now, my lord, by paragraph 12, they are contradicting paragraph 5. In paragraph 5, an impression is sought to be given. My lord, after a person is selected by the APSC, is there any scope of making any temporary or part-time? My lord, these nomenclatures are used in every appointment. Every appointment, government of Assam, they uses the expression temporary. Now, my lord, if I am not substantively appointed, why have you promoted me? Why have you said that I'm entitled to CPF, not regular pension? If my appointment is not substantive, I'm not entitled to either of them. Now their stand is that my service was not regular. These are very irresponsible statements by these deportants. End of the day, a person has rendered throughout his life. Now he's asking for pension, and now the stand taken is his service was not regularized. Is it a responsible way of looking at it? Then paragraph 12, they contradicts me, Lord. They say that as I was absorbed, now they are absorbed, I am entitled to pension as per the board. So that way they are saying that my earlier appointment and everything was okay. If I was not substantively appointed, where is the question of deputation? And
so employees of the board are not entitled to pension?
No. They are not pension under the 69 rules. They are entitled to that CPF.
And they have given you the CPF?
Yes.
But you want to return
I
it
want
now?
to return. I have to return, my lord, because that is how it works. Now, my lord, I am relying on two judgments of our High Court, my lord, where the issue has been settled. Yeah. Bediniti Upadhyay jo diya, duitai di diya ekelage diya. Okay. First, my lord, will have this Bedonidhi Upadhyay is a division bench judgment, my lord. Please come to para 16. More or less identical fact situation. Para 16 at page 6. The above position of law is further clarified by the decision in Union of India versus Parul Devnath, wherein the Supreme Court has pointed out that the direction from the tribunal as well as the High Court in respect of respondent Parul Devnath was for absorption in regular establishment of Andaman and Nicobar Island, and no new appointment was required to be made. The decision in Parul Devnath further clarifies that absorption is not a new appointment, and the government servant on his absorption does not cease to be a government servant, and he has to be treated as a government servant before as well as after his absorption, in as much as a government servant on his absorption does not lose the nature of his earlier appointment as a government servant. In the case at hand, though the petitioner was appointed to the post of LDC at so-and-so on 3/8/2004, on deputation, the fact of the matter remains that he was a government servant even before his appointment in so-and-so, and that when he was brought on deputation from so-and-so to so-and-so, to still remain a government servant, and on his absorption, he continued to remain a government servant. The petitioner's status as a government servant does never lapse. Notwithstanding, therefore, the fact that the petitioner was absorbed as LDC in so-and-so, with effect from 3/8/2004, he was a government servant when he has been working as a helper, laboratory attendant in nearest, and he remained a government servant when he had been working on deputation in so-and-so. And even on absorption, his status as government servant did not cease. In the backdrop of the resultant effect of absorption of the petitioner, when we revert to the new pension scheme, we notice that new pension scheme has come into force with effect from 1/1/2004 and is applicable to all new entrants to the central government service, except to the armed forces joining the government service on or after 1/1/2004. The new pension scheme cannot therefore be applied to a person who is not a new entrant to the central government service, inasmuch as clause 4 of the new pension scheme, when read and reread, makes it abundantly clear that the new pension schemes would be applicable to new government servant, that is, person was not a government servant and who joins government service on or after 1/1/2004. So, my lord, the proposition which is decipherable from the judgment in my humble submission is, once a government servant, he always remains a government servant, and which position is, of course, my lord, reiterated by section 22 also, when it says that my condition of service will not change. Therefore, since I am a government servant and I joined service on 5/7/88, therefore I am entitled to the pension as per the 69 rules. Then now please come to the other judgment, Dolly Borpujari versus State of Assam. This is also a division bench judgment. 3 paragraphs, my lord, paragraph 18, 19, and 20. This was a case where the facts are on a slightly different tangent in as much as he was a contractual employee, madam. Even then court said he is entitled. Para 18. In the present case, the entire defense of the state is that the appellant is not governed by any rules framed by the state under Article 309, and her service was purely contractual. The state also urged that the post which was occupied by the appellant was a temporary post, and therefore appointment of the appellant was not in a vacancy which is substantive in nature, and therefore appellant is not entitled to the benefits of pension. We are of the opinion that the entire exercise of the state is an exercise in semantics. If the stand of the state is that service of the appellant is not governed by any statutory rule framed under Article 309 and purely contractual, it is not understood as to how the appellant could be said to have retired on attaining the age of superannuation. Admittedly, no contract stipulating age of superannuation is placed before the court. On the other hand, the appellant was made to retire on reaching the age of superannuation prescribed for all other employees of the state of Assam whose services are otherwise regulated by rules framed under Article 309. If the service of the appellant is purely contractual, to our mind, the only known mode of putting an end to his service is either by efflux of time stipulated by the contract or by termination of the contract at by an appropriate procedure. We are also not convinced with the submission that the employment of appellant is purely temporary in view of the fact that the appellant was employed for a period of 14.5 years, and since the retirement of the appellant, another person is appointed to the post which was held by the appellant. Obviously, the work and the need to employ somebody to do work continues. The employment remains contractual only because state was either lazy not to frame
appropriate rules under Article 309 or mischievously omitted to frame statutory rules governing the service of the appellant. In either case, it would be an arbitrary omission on the part of the state to discharge a constitutional obligation flowing from Article 41. Rule 93 of the rule provides superannuation pension for such category of employees. We declare that appellant is entitled to superannuation pension as he has served under government in a substantive and permanent capacity for 14.5 years till he was superannuated. In view of the foregoing, we are unable to agree with the conclusion reached by the learned single judge. The appellant was not holding a post on substantive and permanent basis and therefore was disqualified under Rule 31 of the received pension. We hold that the appellant was holding the post on substantive and permanent basis, and disqualification under Rule 31 would not apply to the service of the appellant. Well, this second judgment is basically an answer to the stand of the board that my service was not regularized. So, my lord, I think it's an open and shut case. Therefore, in my humble submission, my lord, the lordship should direct the respondents, including the state, to allow my lord pensionary benefits under the 69 rules. I reserve my right of reply subject to what the other side say.
Yes.
May I please, Your Lordship? Here in this case, the writ petition, the first annexure is page number 16. My Lord, a senior friend has referred to that particular annexure. In that particular annexure, it has been specifically mentioned, I'm just reading that particular annexure, Lordship. The appointment is purely temporary and may be terminated at any time on 1 month's notice on alternative. The services are liable to be transferred anywhere in the state of Assam, including hill areas. So that was the specific mention in that particular annexure, annexure number 1 at page number 16. Now, what has happened, Lordship, subsequently, on 10th of July 89, page number 18, annexure 2.
Yes.
The services of the petitioner, on his service having been placed at the disposal of the Assam Urban Water Supply and Sewerage Board, Guwahati by Municipal Department notification number such and such, is appointed as assistant engineer on.
It's already placed.
Yes.
You
Now,
look
why
at-
I am referring to this particular annexure, Lordship, the stand that we have taken, stand is very specific with regard to the fact at paragraph number 5 that since his service was never regularized with regard to the parent department, and since we have no option for pension, and at that point of time, we are not in a position to give pension to the petition. As per the provision is very clear. I'm just referring to that provision of the this particular the regulation, the 22, the section 22, clause 3. Yes, section 22, 2, clause 3. After 2, then 3. The 2 is that he should be absorbed substantively in the service of the board, and then the board will absorb him substantively in service, and thereupon the service rendered by him under the state government shall be treated as service rendered under the board, and he shall be entitled to have such rights or to such similar rights in the changed situation with regard to the remuneration, leave, and pension, as will not be less favorable to the service conditions, agreements, and rights as he would have been entitled to before he was employed in the board. So the presumption is that whatever he is entitled for in the parent department, he is otherwise eligible, not less favorable to the condition of service. Now, the third point, Lordship, I am just referring to the third one, that he may be permitted to revert to the government service, and he will be allowed to do so on the same terms and conditions as were applicable just before his services are transferred to the board, and he will be deemed to have remained always in the government service under the same terms and conditions. So after this 2, now the 3 comes. Now 22(3). 22(3). If any officer or employee do not give much intimation within the above specified period, it will be deemed that he has opted for being absorbed substantively in the service of the board under the terms and conditions specified by it. So the terms and condition is very clear, Lordship. In the board, there is no provision for pension. And we have subsequent paragraph, we have made a specific stand with regard to that because he has not opted for, because paragraph 2 into 2, 2, 3 is very clear with regard to the fact he has opted for reverting back to the parent department. He has not done. Since we have no provision for pension in the boards, so we are not in a position to give the pension. So we have specified in our affidavit in opposition also, Lordship. I'm just, for a moment, I'm referring to that particular aspect of the matter. If your Lordship kindly see.
Yes.
paragraph number 11. Page 47. Page 47, that with regard to the statements made in paragraph 10 of the writ petition, the answering respondent beg to state that board has taken initiative of his representation dated 27/6/2023, and it is under process. It needs to examine all rules and regulation in the case of the board employee. Hence, it has taken time to dispose of the matter. It is necessary to mention herein that the additional secretary government of Assam has issued a communication by letter dated 11/12/2023 to the respondent number 3, thereby mentioning that the matter relating to pension was taken up for consideration, and accordingly it was decided that the service of the petitioner, since absorbed in the Assam Urban Water Supply Sewerage Board under section 22(2)(2) of the Assam Water Supply Sewerage Board Act 1985. As such, he is entitled to CPF as applicable to the employee of the board in view of pension under Assam Service Pension. And accordingly, the proposal sent for pension was rejected. So this is a very clear stand on the part of the board lordship, because as per the provision, he is eligible to that. But the eligibility would be determined on the basis of the provision that is there in the Act. And as per the Act 22(2)(2), then 3 comes, because he has to revert back to the government, because he did not do that. Since he does not do that, and as such, the provision of 22(3) would come into play, and accordingly, he is eligible for that aspect of the matter which this board is entitled to give. And accordingly, we have given him the CPF lordship, because this particular aspect of the matter we have clarified in our affidavit in opposition also, lordship. And now the reply that has come, lordship, with regard to paragraph 5, with regard to the our objection that has been raised with regard to the fact that his service was never regularized.
So CPF is paid to a person whose service is never regularized. Is that the law under, is that the rule?
No, substantively we have absorbed lordship, and since we have absorbed, the provision of pension is not there in the board. That's why that has been rejected. Even the annexure is very clear with regard to that. If your lordship kindly see the annexure.
No, that is what he's saying. His
Yes.
case is covered under 22(2) Roman 2. That's
Two,
what it
but the
says.
3 is also there, lordship.
If 2 is applicable, 3 will not be applicable.
No, in this case, lordship, the 3, as per the provision of 22(2)(3), since he has not chosen for reverting back to the.
The question doesn't arise. If you
Yes, Lord.
observe him permanently,
Yes, lordship.
why should he choose?
Then if he has been absorbed permanently, then the benefit that he is eligible or entitled for as per the provision of 22(3). So as in respect of that, we have provided in the CPF, and that has been accepted by him long back. Now he is the employee of the board, and that's why it has been given to him. So this aspect of the matter, the affidavit in reply is there. Only the stand that we have taken that has been reverted, and that has been this refuted by making a statement with regard to the fact that with regard to paragraph 5 of the affidavit in opposition, the deponent states that by government notification number such and such, he was appointed assistant engineer, full scale of pay.
That I've seen.
Yes. So our stand is very clear, and whatever
So
is
your stand is 22(3),
3.
which will come into play.
Exactly, Lordship.
22. Consider, yes. Yes, who else? If he succeeds, then government, you will have to take care. So what is your stand? You have not filed any affidavit. So his main prayer is against you.
Lordship, we have received the instruction, Lordship, but the stand taken by them is exactly what is stated by the Sewerage Board, Lordship. So exactly these statements, so that's why we have not filed the affidavit, Lordship. And the stand of the department is further that when he was initially appointed, Lordship, he was not regularized to that post when he was appointed. So subsequently, he chosen to be on deputation on that particular Sewerage Board, Lordship. And he has been absorbed there only. So the pension, what they are, the petitioner is claiming is not applicable to that because he is covered under the this CPF, and he has accepted this. So we have the
CPF
written
came in in the year 2004.
Lordship.
And his appointment and observance were much before that.
Much before that, but he was at that time, Lordship, he was not, that means he was temporarily engaged, Lordship. He was not into his service was not regularized at that point of time when he accepted the post under the
When
Sewerage.
is it regularized? When?
It was regularized subsequently under the board, Lordship. because he represented their lordship for his regularization. And subsequently, he has been substantively lordship, he has been regularized their lordship. So he is guided by the CPF lordship, not by the pension rules lordship. This is not applicable in case of the petitioner.
And has he been making contribution to his CPF since his absorption?
This the board can clarify lordship,
was he
because we
making
are
it-
not their lordship.
Mr.
And he has not chosen to be reverted back to the
That's all right.
this,
Mr. Chaudhary, has he been? CPF will mean that he has to make his own contribution. Has he made it all along? Mr. Chaudhary, as your
Yes,
client.
yes, it was done, my lord, because they deduct from the salary. I have got no control over them. End of the month, they deduct.
But your client was aware.
Yes, 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 yes. That's why in para 17, we have made a statement, will they return our 50% that which we have, they have given us, my lord. In fact, my
Alright,
lord, central government in 1988, when they brought out that notification whereby people in CPF were permitted to switch over to regular pension fund, my lord, then, my lord, there was an option given to adopt one, and in doing so, they will have to return the contribution given by the employer. It's something not new. It is acceptable in this.
Anything?
Small reply, short reply, my lord.
Yes.
Now, if lordship should kindly come to page 50, this is the order by which my claim was rejected. That is after filing of the writ petition on 11th of December 23. With page 50.
Yes.
With reference to the subject cited above, I am directed to inform you that as the service of Sri Azizur Rahman was absorbed in the Assam Urban Water Supply and Sewerage Board under section 22(2) of the Assam Urban Water Supply Sewerage Board, he is entitled to CPF as applicable to employees of the board in lieu of the pension under the Assam Services Pension Rule, and as such the proposal is hereby regretted. Now, my lord,
This
I
is
need
not
not
under- this order is
tweak
not
my
under-
argument.
This is not under challenge. No.
As such, nahi.
It is not on the same.
After filing of the writ petition, my lord, this was issued. And then, my lord,
The-
same prayer we have made in the writ petition. Technically, we have not done it, but lordship can take judicial notice of the fact. Now, my lord, the argument of the board that I have not opted to go back, that option doesn't lie with me, number one. This option which is them, kindly he similar, that he may be permitted to be reverted. In any case, my lord, clause 2 of section 22 subsection 2 is independent. My lord, it is independent of 3. And the subclause 2 ends with a or, not and. So it is disjunctive. That he should be absorbed substantively in the service of the board, and then the board will absorb him substantively in service, and thereupon services rendered by him under the state government shall be treated as service rendered under the board, and he shall be entitled to have such right or to such similar right in the same situation with regard to remuneration, leave and pension, as will not be less favorable to the service condition, agreements and rights as he would have been entitled to before he was employed in the board. So, my lord, if we give a literal meaning, my lord, what clearly flows is that I will be entitled to my rights which I would have enjoyed as a government servant. And my lord, Supreme Court and our division bench has already said that once a government servant, I will be always be government servant. By merger, my absorption of my mind with the board, I does not lose my status as a government servant. That continues. And 3 will come, my lord, in a situation where a deputation is, he opts to go back. Here in this case, my lord, normally what happens? Deputation tenure is maximum for 5 years. So before that, one has to, but they themselves have, my lord, absorbed me. Look, these are all policy of the government. How does an employee or a government servant do anything? Therefore, my humble submission is, my lord, this reliance on Rule 3 is of no avail. And my lord, my service condition cannot be changed. it will remain. And that is what the division bench of our High Court has also said. That is my humble submission.
Judgment reserved.
Mine.
Deep, what is this? Huh?
May not be.
You keep it, you'll need it.
Yes. My lord, matter relates to old pension and new pension, my lord. Lordship already.
My lord, in this matter, finance is required. My lord, my friend P Naik is in another court, my lord. He will come, my lord, after some time, my lord. He just informed
Lordship
me.
already decided the issue and the lordship has passed the order
If it has been filed.
along with Honorable Chief Justice, my lord.
My lord, it's a long settled, even we will also say that it is settled position of law, my lord. My lord, only the thing is that he wants to argue the matter, my lord, my friend. He's in another court on legs,
We'll have it on a non-miscellaneous day, next Thursday.
my lord.
As requested by learned counsel for both the sides. Next Thursday. Yes.
So the matters become
Perhaps
infectious.
it's made in the morning that.
Yes, sir, it become infectious.
All three have become
All.
infectious. Why?
Yes, because already they
They have
undergone,
taken VRS, your lordship.
they have
All
taken
of them has gone for VRS.
You are Mr.
P Sharma, item number 29.
And what about item 28 and 30?
20 and 29.
Who is appearing for 28 and 30?
BD does senior counsel.
He appeared in morning, actually. He was. Yes, good, he was good.
In the morning mention was made.
Mention koi se. He mentioned in the morning hour, your lordship. I was not
Noted
present.
down.
actually.
Mr. D. Kalita, learned counsel for the writ petitioners in item number 28 and 30. And Mr. P. Sharma appearing for the writ petitioners in item 29. Give the case numbers. I have submitted that during the pendency of this writ petition, their respective clients have gone for voluntary retirement by accepting the VRS scheme, and therefore nothing survives for adjudication in this writ petition. Mr. N.J. Gogoi, learned counsel for the board.
Both respondent 3 and 4.
Respondent numbers 3 and 4. Open Miss. Miss M.M. Kotoki for respondent numbers 1 and 2 are present and have confirmed the said position. In view of the above, these three writ petitions stand disposed of as infractious. Any interim order operating?
No loss.
Interim process? No. Yes,
Public-
infractious disposed of. We have recorded the name of Mr. D. Kalita. Tell him. You are not on record.
Apply this.
May I please also? The petitioner also, he has retired as an assistant employment official also. Also, due to non-regularization of a particular period, also, I have been assessed for a lesser pension also. I am paying for regularization of this particular period also. With effect from 15/12/89 to 30/11/1993.
Yes, who is appearing for the? You are appearing?
Lordship, the petitioner had filed an IA for implement. Principal Secretary to a Government Department of Skill, Employment and Entrepreneurship.
No, that is only for the signs of post title. Okay, we have made a typographical error. On the very first day also, we have done.
There's a standing counsel for it.
Might will file the affidavit, madam, by week, madam. By 1 week, madam, we'll file the affidavit, madam.
No, but this is 2023 matter. Why you
Madam,
are
madam,
appearing for whom?
I have received, madam. Madam, I'm appearing for respondent number 4, madam.
So he wants to file affidavit. We'll give him 2 weeks' time.
Madam, 1 week, madam.
Mr. So-and-so, learned counsel is present for the SK Das, learned counsel for the petitioner is present. On the Miss U Sharma, learned G Assam is appeared.
For 1 and 2.
Numbers 1 and 2. On the request of Mr. SP None has appeared for respond number 3. On the request of Mr. S.P. Das, Learned Counsel for the respond number 4, this matter stands adjourned for 2 weeks so as to enable him to file counter affidavit. List this case again after 2 weeks.
Your lordship, they, 2 weeks time may kindly be granted for filing affidavit.
Because the last occasion, this was given as the last occasion to file. In any case, if they file in the next day, will not object to it.
You have already taken time.
Yes, your lordship, sorry for another 2 weeks time, your lordship.
So a fixed date maybe.
Mr. D. Dekar, Learned Counsel is present for the writ petitioners. Mr. K. Kumar, Learned Additional AG, State of Assam, appearing for the PNRD department, has prayed for further 4 weeks' time as last opportunity to file affidavit. Considering the nature of issue involved in this writ petition, prayer stands allowed. Let this writ petition be listed again immediately on reopening of the summer vacation. It is, however, made clear that if no counter affidavit is filed by the respondent by the next date, this writ petition shall be taken up for disposal on the basis of materials already available on record.
Of right, your lordship.
Yes.
This matter can be disposed of because there is an affidavit which has been filed by them. He was holding the post of joint director. Now, then he retires. If your lordship looks into it, the promotion, last promotion he got at page 41. I'll make it very short, my lord. 41 kindly be seen, my. Then now they have filed an affidavit. That's this promotion to the post of joint director. If your lordship looks into it, on the second, there are 3 promotion which has taken place. Middle one, subject reversal in notice, so and so. Konakeshwar Borgohai, TPRO, Assam Police, so and so is promoted rank of joint director, information public relation, the pay band of so and so. So this is 21st of October 2013. I was continuing. In the meantime, at page 42, a so-cause was issued. 12th of October 2018. Next page, my lord. Now, this so-cause was withdrawn by the authority at page 48. They have issued a fresh so-cause. Kindly see at page 48. Serve your fresh so-cause at page 48. 17th of November 2018, a fresh so-cause has been issued. Now, this is the so-called charges which has been laid down, and in the charges, my lord, it appears, page 49, if your lordship looks at paragraph 1, it is I was joint director, and if you see first, second, third, fourth, fifth line, you have aided and abetted the then DIPR entire scam. So they said misappropriation of, in the first, 30 crore 6373. This is the allegation. So-cause. Please mark 1, 30 crores and aided and abetted. Lordship got it, my lord? Now there is a reply which has been filed, which is at page 57. I filed a reply. 1st of December 2018. Reply has been filed. Now at page 63, inquiry officer appointed. Page 63. That is somewhere in 2019. If your lordship turn to page 64, presenting officer. At next page 64, presenting officer.
So what is the issue here?
Now I'll just tell, just that we are coming to conclusion list. I retired in the meantime on 30/11/2020 on next page 65. Page 65, 30/11/2020 I retired. Now, after retirement, my lord, I represented before the government that some pension has to be paid. They paid the provisional pension to me. Provisional pension was paid. But I said before when I come to the court, representation was filed. Director, the then director, who was the main, he was charged also, criminal also, he was taken into custody also, he was placed under suspension, but not in the case of this job, because he said, I aided and abetted. Now, in respect of the director, but he has been exonerated. I have annexed that. He has been exonerated. Now, this proceeding is going on. What I say to the court that either you finish it off the department proceeding within a period of 3 months, you have not done it. When this writ petition were presented before this court, what they have done, my lord, a fresh hearing, they have issued a so-called notice to me, further hearing on 5th of December 2023, which I filed an additional affidavit before this court. Now, I say before the court, IA, CIA, my lord, 3886, the IA. Give me 2 minutes, I'll just finish it off, my lord, 2 minutes. See at page IA 3886, last page, 16, sorry.
Yes.
This is what they have, the dependency of written 5th of December with reference, you are hereby requested to attend for hearing in connection inquiry, so and so on 14/12/2023. My submission was before the court that if it is a continuation of the earlier inquiry, no problem. I will participate within 3 months. If it is a fresh, then I will place it. Now, what it appears, there is an affidavit which has been filed by them. It appears it's a continuation. Kindly see at page 83 of the affidavit.
What is the prayer in the IA?
IA is that my IA to quash the charge which has been leveled against me. So course. But see, please, the affidavit which has been filed by the government at page 83, para 7. Para 7.
Yes.
That the deponent states that the process of inquiry is being continued with a view to find out the fact notices to so and so, so and so. So, at page 83, para 7. So, my lord, you got it?
Yes.
See para 7, that the deponent state that
Page 80.
this is marked as 83 here, affidavit.
There's some problem here. Pagination.
Affidavit in opposition by the government.
Have a look. It's not telling. Government means respond numbers 2, 3 and 4.
Yes, sir.
Yes.
Starts from page 87.
Okay. I think he's marked your lordship's.
No, it is second.
So,
That's your remark.
we can take it.
90. Means 83 was there, but they have. But means 90.
Original 83 page number was there, but it has been, the cut mark is there.
Well, whatever is page 90. There's only one paragraph. One paragraph. See para 7, my lord. Para 7. Process of inquiry is being continued with a view or to final fact, notice to witness, so and so, so and so, so and so. So if it is a continuation, my lord, let them finish it off the proceeding within a period of 3 months. There is provisional pension. And similarly, who is, my lord, the main person, director? My lord, we got the copy and he has been exonerated. And they said I aid and abetted. Even then, kindly see, all pensionary benefit he got. A director is a main and he is facing the trial. Let it be within 3 months.
Also, my submission is that, in meeting what my senior friend has said that the next order of next date of hearing at 9/1/24. You see, I have the record. I have examined some the office notes of the record. You see, the inquiry report that has been submitted, it has been stated that no, as he is going to be retired at that time. So that is the case, Lordship. So we are not going to impose any major punishment upon you. Only the punishment he will be getting is censure. A second thing is that towards the end of the office note of the record, it's been stated that the period of suspension that will consider it is an on duty. So that's what record says, Lordship. And if Lordship directs me to this thing to conclude the departmental proceeding within a period of.
No, what has happened to the departmental proceeding?
Yes.
Basically, these are, no, basically, these are the decisions, Lordship, and the records are pending before the court. So in that case, Lordship, as the records are before the court, Lordship, the departmental proceeding, Lordship, the records we have to send back, Lord, with a direction that, it has to be finished within 2 months or 3 months like that. We have to send it, but otherwise, Lordship, towards the ends of the office note, we are on a view that he is not getting any major punishment, only censure, and the period of suspension will be considered as on duty.
I retired, whatever. If you are treated,
that- that
if
on
you are treated director one, who is the main person, and he has been exonerated, he got all the pension, why I should?
So you are saying, from where are you saying that?
From the
only
record,
pension-
Lordship, yes.
Which part of the record?
No, sir, I'm sorry.
Then we'll record his submission and dispose of. the
Lordship may
matter.
kindly see page number 13. Lordship may kindly see page number 13. And
Page
page
number 13 of,
of the record law. So it is basically the office note. And
oh, record is with you and how can I see it?
no, I'm just providing Lordship. I'm just the another Lordship and page number 26. Lordship may kindly see page number 13 and page number 26.
The director also been treated as on duty, but he's been totally exonerated. They cannot take a different standing. I aided and abetted, they said. And he has been charged, criminal cases going on against him.
So this shows the inquiry report has already been submitted.
Yes.
Then
Then in the inquiry report, it has been stated that basically the views of the inquiry officer is that no pressure punishment may be given to him because he is going to be returned and considering upon his previous experience was it.
heard Mr. Deedas Lane, senior counsel, assisted by Mr. H. Hamid Lane, counsel for the petitioner. We've also heard Mr. CKS Barua Lane, G. Assam appearing for the respondents, full stop. The petitioner herein retired from service with effect from 30/11/2020 on attaining the age of superannuation as the Joint Director, Information and Public Relations. Full stop. The grievance of the petitioner is that due to pendency of a departmental proceeding, his regular pension has been withheld. It is also the submission of Mr. Das Lane, senior counsel for the petitioner, that on one hand, the respondents have exonerated the Director of Public Relations,
I have given a copy to your lordship.
namely
Copy reason?
Sri Ranjit Gogoi, against whom the main allegation of embezzlement of public fund was brought in. And on the other hand, the authorities are delaying the process of conclusion of the departmental proceeding initiated against the petitioner, although there is no iota of material available against him to establish the charge. Full stop. Contending that his client has been unduly made to accept provisional pension several years after, even several years after his retirement, the instant writ petition has been filed. Mr. Das, and a senior counsel, has further submitted that since there is no certainty as regards the timeline for completion of the departmental proceeding, either a time frame be laid down by this court for conclusion of the same, or in the alternative, a direction be issued for sanctioning the regular pension of the petitioner. Full stop. In support of his above argument, Mr. Das has produced a copy of the order dated 31/8/2022 issued by the Commissioner and Secretary to the Government of Assam, whereby the then DIPR, Sri Ranjit Gogoi, was exonerated in the departmental proceeding against, drawn against him on the same set of allegations, but with more gravity, and even his period of suspension with effect from 7/11/2017 to 19/5/2022 have been regularized, whereby it was observed that the said period of suspension shall be suspension part na lage. No. No, he was not exonerated. It's a
No, no,
compulsory
fine.
retirement. Why do you say exonerated?
No, no, we say entitled to order so and so. Kindly see. Enquire material record so and so decided so and so when the public service governor pleased to penalty of compulsory retirement and subsidy upon so and so. Further, the government is pleased, pension, my lord, is pleased to order that a period of suspension shall not be
No, no,
entitled.
he was not exonerated.
But he got entire benefit.
Oh, Mr. Das,
We
you said he
also-
was exonerated.
No, I'm sorry, he's got the benefit.
That is not a right submission. You made
I'm
a-
sorry, my.
The period of suspension, we are going to also treat it as non-duty.
Then you change that. Whole order has to change. Wherever written exonerated. Wherein although the penalty of compulsory retirement from service under clause 4 of rule 7 of the Assam Service disciplinary and appeal rules, appeal clause rules 1964 was imposed upon Sri Ranjit Gogoi, yet he was allowed to draw pension, Mr. As such, the learned counsel for the petitioner has prayed for an order to expeditiously conclude the departmental proceeding initiated against the petitioner by bringing same to its logical conclusion. Mr. Responding to the above, Mr. Sikiel Burua, learned government advocate Assam, has produced the departmental records to submit that the enquiry officer has already submitted enquiry report in the proceeding drawn up against the petitioner, whereby a recommendation has been made that only minor penalty of censure be imposed upon the writ petitioner and his period of suspension be regularized. Mr. Borua, however, submits that due to pendency of this writ petition, no further action could be taken in the matter by the government. Full stop. Having regard to the submissions made at the bar as noted above, and considering the nature of grievance expressed in this writ petition, the nature of grievance expressed by the petitioner, this writ petition to be hereby disposed of with a direction upon the respondents to bring the departmental proceeding to its logical end as expeditiously as possible, but not later than 3 months from the date of receipt of a certified copy of this order. Stop. Needless to say, while doing so, the departmental authorities shall also consider as to in what manner the period of suspension of the petitioner. What is the period?
He has not been suspended.
That's what.
That's
Then is not required. Needless to mention herein that the respondents shall also consider as to whether the final order sanctioning the regular pension of the petitioner is required to pass and do the needful in that regard. Writ petition stands disposed of accordingly, and in view of the order dated so and so, IS stands closed. And then you write the departmental records be returned to Mr. C.K.S. Burua. Take back the record. We'll see there are some changes. to the order.
Sorry for that, man. Sorry.
Yeah, but I thought
No, I
he was.
was sorry. And actually, what has happened that 30 crores, I have seen this order here, there are 30 crores in respect of the charges which is level, That recommendation has been dropped. Here at page 70, it has been dropped. 74, the 73, the charges framed against dealing officer is not correct.
There could be minor changes
Yes,
in the order.
just your lordship can look into it, page 72, 70.
That will not go into it.
Yes, it has been dropped 30 crores. That was the main allegation level against.
All right, yes.
Deeply obliged, ma'am.
Yes.
Lordship, in this case, Lordship, the petitioner was working as a meter reader in the Hasbu Electrical Subdivision. He was under put to show cause, followed by a purported inquiry behind his back, Lordship. Under inflicting him some frivolous charges, by he had to go under compulsory retirement on 18/8/2014. Lordship.
So this will require final, have you filed affidavit?
No, my lord, we've not, my lord.
Why you
Last
don't file?
We'll file, my lords. We're just awaiting the instruction and the records are.
Oh, you were,
My lords, we'll get that, my lords.
all right, heard Mr. Your name, please?
D. Burman, Lordship.
D. Burman, counsel for the petitioner, also heard Mr. P. Chaudhary, learned standing counsel for the APDCL, who prays for 4 weeks further time as last opportunity to file affidavit. Prayer allowed as last opportunity. Let this matter be listed again after reopening of the summer vacation. The respondents to bring their stand on record by filing affidavit on or before the next date fixed.
Deeply obliged, Lordship.
Basic differences, my lord, whether my lord BSc in laboratory technician is equivalent to my lord BSc.
Pleadings complete.
My lord, complete, my lord.
Then we'll fix it for disposal. Today it's not possible.
That fix.
Yes, when do you want it? And Mr. A. Khonigal, counsel for the petitioner, and Mr. K. Gogoi, and counsel appearing for the respondents, submits that pleadings have been exchanged in this case. Considering the nature of issue involved in the matter, the read petition can be taken up for disposal at the stage of admission hearing. Taking note of said submission of the learned counsel for both the sides, registry is directed to list this matter again on 17th of June for admission hearing as a fixed item.
Deeply.
Kindly peruse the order dated, my lord, 3/10, my lord, 24, my lord.
Yes.
On that day, my lord, the standing counsel PNRD is seeking time, my lord, to receive instruction. But
Yes, PNRD.
Yes, Your Lordship, I am appealing.
Yes, you have not filed affidavit.
Sorry, Your Lordship, we failed to file, Your Lordship.
One last chance.
my lord,
Heard Mr. K. R. Patgir, learned counsel for the petitioner on the request of Mr. K. Court, learned additional AG for the state of Assam, representing the PNRD department. 4 weeks further time is granted to the department file affidavit. List the matter again after the reopening of summer vacation.
Here, Your Lordship, in this matter, from his pleadings, Your Lordship, we appears that his basic grievance is against the director of pension. So he also finance, maybe also directed.
Ms. U. Sharma, learned G. Assam. How about the Mr. B. Gogoi, learned additional AG Assam Finance, and Ms. U. Sharma, learned G. Assam are present and are granted 4 weeks time to file affidavit in the matter. List again after the reopening of summer holidays.
Yes.
Obliged.
But
In the matter, my lord, some misleading has been committed by the respondents council, my lord, of their authority concern, my lord. Since lordship passed the order on 29th of January, my lord, on the basis of the instructions furnished by them, it was clearly said that since a DLC has forwarded the matter and the government was asked for get the instruction from the SLC whether petitioner case has been considered or not. On the basis of their instruction. Now subsequently they have reversed saying that there is no such a DLC recommendation, all this. When the government inquired, then the standing council of PHE said that there is no such a DLC, all these things. Meaning there, by my letter, they are misleading this honorable court this way, that way, my lord. What is this, my lord? There should be limit, at least that should not be happen, my lord, in this.
Basically, this is the instruction that we have received. Due to lawsuit, that cases of lawsuit late submission. His case, application would not be. Reason is that lawsuit, it was been not recommended by the DLC case of lawsuit late submission lawsuit. That instruction has been provided to me.
But earlier you made a wrong prediction.
No, Lordship, at that time, Mr. Arbor appeared, he overlooked the instruction, the DLC then recommended, Lordship. He overlooked the instructions and submitted before this court, Your Lordship.
Yeah, DLC did not recommend it.
DLC did not recommend it, he overlooked the instruction, Lordship.
So then you have filed your affidavit.
We'll file this appeal, we even here received the instruction.
That not recommended, my lord, that has been under challenge, my lord, in 2019, and that lordship has gone through it in 19, my lord. That
Alright, so today what is to be done? Let him file the
Yes,
affidavit.
lordship.
Yes. You will file.
Well, fine.
Yes,
Yes,
heard Mr. B. Chetri and counsel for the petitioner. Also heard Mr. C.K.S. Burwal. No, B. Chetri and counsel for the petitioner who submits that a completely misleading and incorrect submission was made earlier by the Learned Standing Council PHE department. And therefore, the matter deserves serious view of the court. Full stop. Mr. C.K.S. Burwal, Learned G. Assam submits that affidavit. You have already filed
We
affidavit.
have already filed the affidavit.
Submits that affidavit on behalf of the respondent number 3 has already been filed. However, Mr. R.R. Gogoi, Learned Standing Counsel for the PHE department, Assam prays for how much time?
2 weeks time, my lord.
2 weeks time to file affidavit on behalf of the department. First, a prayer allowed.
Lordship will
let
take
the-
that. Other earlier occasion also they sought for 2 weeks time.
Let the writ petition be
Even
listed
after
within-
2 months, they could not file.
on 23rd of June 2025 as a fixed item. The respondents to complete their pleadings on or before the next date.
Lordship.
Hello, may I please your lordship, my lord. Here in the instant case, my lord, some development has took place, my lord. There is a determination of seniority between me and respondent number 4, my lord. Now the respondent number 4 has retired, his service has been extended, my lord. There is a dispute between the gradation between the petitioner and respondent number 5. Now 4, my lord, sorry. Horen Kumar Sharma. And my lord, it is reflected on the gradation list also, ma'am. May I read, my lord, that his extension I have already given? That Sri so-and-so has been, his service has been extended for the period of.
Yes.
In pursuance of government letter so-and-so, dated so-and-so, the retirement age of Horen Kumar Sharma received and Lok Sabha Parivar for the year is hereby extended 1 year of service in the same capacity as senior assistant. His date of birth is 1/3/1965 compared to 2/3/1966 as per OM so-and-so. Again, the following extension of service 1 year. The date of the Horen Kumar Sharma assistant will now be instead of original retirement 31/3/2025. There is a notification, he cannot get the mile promotion mile as per notification of the
So
government mile.
is it a part of the record?
This is the part of the record by law, because after filing all these things, I got this.
Correct. So why don't you bring it on record?
Yes, sir.
How much time you want?
I need my law, 1 week, my law, next week, my law.
All right.
Any-
Mr. NNV Chaudhary and counsel for the writ petitioner submits that during the pendency of this writ petition by issuing office order dated 25/4/2025, the authorities have extended the service of the respondent number 4 till 31 by another 1 year. That is till 31/3/2026. Full stop. Mr. Chaudhary seeks a week's time to bring the aforesaid notification on order and by suitably assailing the same so as to protect the interest of his client. The prayer is not opposed, hence the same stands allowed. Let this matter be listed as soon as the additional affidavit,
I file on my law.
as soon as the additional affidavit is filed by Mr. Chaudhary by serving an advance copy upon the respondent's counsel. You file it whenever you file it, it will be. Yes.
But see, last time the other party prayed for 2 weeks' time for submitting that affidavit. Even after 4 weeks also, they have not submitted the affidavit.
My Lord, he has filed one amended writ petition.
Hmm.
My Lord, it has been brought to my notice yesterday only. I do not know whether any new amendment has been made. My Lord, I will see to that, let it come after 2 weeks, my Lord. If need be, I will file, otherwise it may not be necessary to file also.
What is his grievance here?
My Lord, upgradation for my Lord APR, this annual performance appraisal report. My Lord, it was sent back to the authority to scrutinize it. After seeing the record, they have found it is okay. Because the reporting officer who was there earlier, he has been since been retired. So therefore, on the basis of the record, they have checked it and they found it okay. And my Lord, so far, this is the role of the administrative authority, my Lord. And the reporting officer, he was in that relevant time, he was in the regional office. And the region, his performance was assessed by the next reporting authority.
He is still service.
No, no, he has since been retired.
Retired.
May I please, Lordship? Actually, the case is I was disqualified on the basis of an uncommunicated APR. So I had filed an original writ petition before this honorable court. The court found my disqualification as irregular. And court had passed certain instructions. One of the instructions was for an objective review of my APR. Then I submitted a representation. That representation was arbitrarily rejected. Then I filed a second writ petition before this honorable court. The honorable court was kind enough to set aside and reject that review being done by the earlier authority. And they remanded back the matter to the authority asking for a repetition of the review, objective review. And this time this honorable court gave a detailed instruction of how to do an objective review, what are the essential elements of an objective review. But what they have done again a review, but the review is nothing but a repetition of the earlier review only. So I have challenged the second review which has been done by the authority. This is an arbitrary one based on surmises and conjectures only. There is no material facts, and whatever essential elements were required to be there in that objective review as per the order passed by this honorable court, nothing is there in that order. That is why submitted this writ petition. And this amended writ petition also, Lordship, I have submitted much earlier. There was a hearing also last time. They had appeared and then they prayed for 2 weeks time for submitting. You can kindly see the order dated 25th of April.
We'll give him one last opportunity.
Yes, Lordship.
Then you file it by 25th June. We'll have it on
Yes, yes.
25th June. Mr. Debashish Roy, the petitioner is present in person. A person and submits that despite availing a number of adjournments, the respondent.
Once only we took time.
Despite availing an adjournment on the last date, the respondent bank has not yet filed counter affidavit. Full stop. Responding to the above, Mr. S. Datta Lanik, Senior Counsel, listed by Mr. S. Datta Lanik, Counsel for the respondents, submits that due to an amendment petition filed by the writ petitioner, there was some communication gap which had resulted in non-filing of the affidavit. Mr. Datta is however assured that within 3 weeks from today, the counter affidavit on behalf of the bank will be brought on record. In view of the assurance given by Mr. Datta, office to list this matter again on 25th of June 2025 as a fixed item. In the meantime, the respondents to file counter affidavit by serving advance copy upon the petitioner.
Much obliged.
I think. Your Lordship, pleadings are otherwise complete, some automatically taken on hearing day, Your Lordship. Records may also be called.
Mr. D. Das Lalit, Senior Counsel, appearing for the petitioner as well as.
No file.
As well as Mr. D. Bora Lalit, G. Assam, appearing for the state.
Affidavit has not been filed. The private respondent has appeared in this case.
Then you write Mr. D. Das Lalit, Senior Counsel, is present on behalf of the writ petitioner. Mr.
And Gogol.
N. Gogoi Lalit, Counsel for the respondent number 5, raised for 2 weeks further time to file affidavit. Mr. D. Bora Lalit, G. Assam, appearing for the state as well as Mr. S. Datta. for respondent number as Dattal and Standing Council Revenue Department Assam appearing for respondent number 1. And your form
Respond number 234.
234, you were submit that pleadings on behalf of the official respondents has already been filed. In view of the above, let this matter be listed again after 3 weeks
After 3 weeks.
as a fixed item so as to enable the respondent number 5 to file affidavit.
Date, if it is possible. Possible.
You choose a date, 3 weeks.
Any date which is
18th June.
18.
18th June, yes.
Only for the earlier matter.
No.
This, because normally it is briefed and I.
Lordship, I'm praying for some more time to obtain instructions and
Who are you?
on behalf for the PNRD department.
Mr. K.R. Badgeri, Learned Council is present for the petitioner. Ms. U. Sharma, Learned G. Assam, and Mr. P. Nayak, Learned Additional AG, Bracket Finance, Government of Assam are present for their respective clients. On the request of Mr.
AK Ghosh on behalf of Mr. K. Kumar.
A.K. Ghosh, Learned Council appearing for the PNRD department, that is respond numbers
1, 4 and 6.
1,
4 and 6.
4 and 6. This matter stands adjourned for 3 weeks so as to enable him to file affidavit. Mr. Paul.
In this case, my lord, I am challenging the selection process for the post of my lord, cultural development officer. My lord, primarily on the ground that the selected candidates, my lord, who have made respondents here in, my lord, they do not, my lord, possess the requisite qualification with regard to the recognition, recognized university or the institute. And
So, this matter is otherwise, it'll require a
I
hearing.
filed affidavit, but there is no rejoinder material.
Will be filing, but here, my lord, the APSC has raised a question. My lord, they said, we said that it is the recognized university or the institute of the government of Assam. But they said in recognized institute of any state. So therefore, my lord, the
That's right. So do you want the matter to be decided now and file the rejoinder later, or first rejoinder and then to be decided?
Well, I'll file the rejoinder.
file a
At
rejoinder.
the same time, my lord, the government's affidavit will be my lord, required whether my lord, this recognition what the APSC is trying to my lord, interpret that the recognition of any my lord, the state would do. My lord, so therefore, Commissioner.
All right, Mr. P.J. Sikal and his senior counsel appearing for the writ petition has submitted that a copy of the affidavit in opposition filed by respond numbers
2 and 3.
2 and 3 has been received, and therefore he be granted 2 weeks' time to file rejoinder.
Respond number 10 has also filed affidavit, will file the rejoinder.
2 and 3 as well as respond number 10 have been received, and therefore he be granted 2 weeks time to file rejoinder. Ms. M. Bhattacharjee, Learned Additional Senior Government Advocate Assam, appearing for respond numbers 1 and 4, submits that counter affidavit on behalf of the state is also ready and shall be brought on record within 2 weeks from today. Ms. P. Bora, Learned Counsel is present for respond number 7. Your 7, 14, 16.
They also file affidavit.
And it was 7, 14, 16, 21 and 26 is present and submits that counter affidavit on behalf of her clients have already been filed. Be that as it may, on the request of Learned Counsel for the parties, this matter stands adjourned for 4 weeks so as to enable the parties to exchange pleadings.
Deeply.
45 is there. Just wait. What about 46? Who is there?
I'm there.
Yes, this is 46. You are appearing.
Transfer matter.
What do you want?
Lordship, Mission Director filed affidavit on 21st May. We will file reply and 4 weeks time will be granted.
My lord, it's a transfer matter, my lord. So some urgency, my lord. What has happened is, my lord, it is a mutual transfer on the request of the writ petitioner and the private respondent. A transfer order was issued. Subsequently, my
Well,
lord,
we'll fix it and we'll
any
fix
day,
it
my lord,
on
hearing this.
on 9th June for disposal.
My lord. 9th of June.
Learned counsel for the petitioners seeks 10 days time to file rejoinder in response to the counter affidavit filed by the mission director NHM. That is the response number 2.
My lord.
Full stop. Considering the nature of issue involved in this petition, prayer stands allowed. However, taking note of the urgency expressed in the matter by Mr. Gogoi, learned counsel appearing for the response number 2, this writ petition is directed to be listed again on 9/6/2025 as a fixed item for final disposal at the stage of admission hearing.
Lordship.
Rejoinder affidavit, if any, to be filed by the petitioner by serving advance copy upon the respondent's counsel on or before 5/6/2025.
Yesterday they have filed and reply, my lord, that also may be brought on record, my lord.
Registry to list the matter again by tagging the pleadings filed by the parties on record. Mr. B. Sharma, learned counsel is present for
Response number 8, my lord, private respondent.
private respondent number 8. Ms. U. Sharma, learned G. Assam is present on behalf of respondent number? Respondent number 4.
Lordship, interim orders may be
Interim
continued.
order passed earlier to continue till the next day.
Last.
What is this, Miss Case?
It's for restoration of the petition, my lord, which was dismissed for default on 2/5/2024.
Where is the order?
My lord, the order starts at page 11.
Should it go to the same bench?
In fact,
Not
this
required.
matter is for restoration, barely.
Any
for-
objection? Heard Mr. M. Sharma, learned counsel for the petitioner. Also heard Mr. D. Upamanu,
For
learned
the health
counsel
department.
appearing for the,
Health Department.
give me the opposite party.
1, 3, 4, and 5.
Opposite party numbers 1, 3, 4, and 5.
And
Mr. B. Gogoi,
Respond.
learned additional AG Assam is present for response number 2. Full stop. This miscellaneous case has been filed with a prayer to restore the writ petition by setting aside the order dated 2/5/2024 passed in WPC number 3653 of 2014, by means of which the writ petition was dismissed for non-persecution. I peruse the statements made in the petition explaining the default on the part of the petitioner. The learned counsel for the opposite parties submit that they do not have any instruction to file objection opposing the prayer made in the miscellaneous case, made in this case. Full stop. In view of the above and after considering the submissions made at the bar, this court is the opinion that the petitioner has furnished sufficient explanation for the default, for their default, leading to the issuance of the order dated
2/5/2024, my lord.
2/5/2024.
Yes.
As such, the order dated 2/5/2024 is hereby recalled. The writ petition being WPC number so and so is hereby restored to its original file. Registry to list the writ petition for necessary orders after 2 weeks. Miss case stands disposed.
highly.
That's true, my lord.
What is there?
My lord, the petitioner has been imposed a penalty of censure. He was appointed as an inquiry officer. He submitted his report. Disciplinary authority, if not satisfied, they can disagree. But instead, my lord, a disciplinary proceeding has been initiated against me, my lord, and initially one increment was withheld on appeal, now censure.
So this will have to be disposed of.
I am.
Today not possible. Choose a date after 1 week. Mr.
Any
J.
date, no.
Patwari, learned counsel for the writ petitioner. Also heard Ms. U. Sharma, learned G. Assam appearing for the state. It is submitted at the bar that pleadings have been exchanged in this case, and therefore the matter is ready for disposal. In view of the above and considering the urgency expressed in the matter by Mr. Patwari, can you choose a date, non-miscellaneous date? This writ petition is directed to be listed again on 12th of June 2025 for admission hearing as a fixed item. An attempt would be made to dispose of the writ petition at this stage of admission hearing. Parties to come prepared accordingly.
Obliged.
The affidavit filed by the contender number 4
reveals that the matter is now pending with the finance department. Initially, notice was not issued to the container number 2 who represents the finance department, but they can have their instructions, madam. Container number 4 affidavit. at
Anybody
para
from
4.
Finance Department, Assam?
Yes. Who is it?
Let me on Friday next month.
Yes. Mr. R. Majumdar, Learned Counsel is present for the petitioner. Mr. C. Sharma, Learned Counsel has appeared for respond numbers.
4, Lordship.
You don't know.
Lordship 4.
What?
Notice has not been issued. I will have the instruction there also.
On the request of Learned Counsel for the parties, let this matter be listed again next Friday by showing the name of Mr. B. Gogoi, Learned Additional AG, bracket Finance, bracket close Assam. Mr. Gogoi to obtain instruction as to the steps taken by the department pursuant to the order of this court. A copy of the contempt petition be furnished to Mr. Gogoi during the course of the day. Yes.
Published. Okay. Published.
May I please, your Lordship. Also, in this matter, Lordship, for respondent number 7, we took steps, Lordship. But in the report says as addressee left without instruction, hence redirect to sender. Let's say then we were prayed that it should be considered as deemed served. But Lozima said that we should take instructions, Lordship. Then we took instructions from the petitioner, Lordship. She told us that he is now a resident doctor in Assam Medical College, Dibrugarh, Lordship. Then we prayed for, on the subsequent date, we prayed for Dusty services. But Lozima court said that we cannot take Dusty in that address. So we have to change the cost title for that reason, Lordship.
So what do you want to do now? Change the cost title?
Lordship, that is his present, the medical college is his present address, Lordship, but the.
What do you want today?
Lordship, Dusty may be allowed, Lordship, but we want to keep both the addresses, Lordship. We want to try in both the.
No, you cannot take step in an address which is not a part of your cost title. You cannot. That is not permissible.
Then
Then
we
you
may
have
be allowed.
Huh?
We may be allowed to change the.
Then you file a cost title where you give alternative address, then you can. Mr.
A. Mena, Lordship.
A. Menel and counsel for the petitioner prays for and is granted 2 weeks time to file amended cost title bringing the alternative address of the petitioner on record so as to enable him to take steps. Alternative address of the respond number 7 on record so as to enable the petitioner to take fresh steps by way of registered post with AD as well as best service. Mr.
P. Hazarika.
P. Hazarika, Learned
representing
Counsel is present for the
456.
respond numbers.
Respondent 456.
Miss U. Sharma. U. Sharma, G. Assam, for respond numbers 1 and 2.
Only one.
Only one none appears for the remaining respondents. Yes. Only 2 cases, 2 matters. We'll finish it off.
May it please your Lordship. Lordship, on the last occasion, we were directed to serve fresh copies. We have served, Lord.
Fresh copies upon?
Of the writ petition on the office of the senior government advocate, accountant general and CGC, Lordship.
You received copies? Okay. So you're Mr.
Z Islam, Lordship.
So Z Islam Learned Counsel is present and submits that in terms of the order passed by this court, fresh copies of writ petitions have been served upon Learned Counsel for the respondents. Mr. D. Bhattacharya, Ms. M. Bhattacharya and Ms. P. Thakuria appearing for the respective respondents have confirmed receipt of the same but have prayed for 2 weeks further time to obtain instruction. Prayer allowed, list the case again after 2 weeks.
Oblige.
May I please, Lordship?
Yes.
I want to withdraw the instant writ petition because during the pendency of the writ petition, I have been promoted, Lordship. Further, my humble prayer before your Lordship, my seniority will be count from the date which I should have been promoted, Lordship.
That you can't get an order like that in a withdrawal. Then after they finalize seniority, you come back.
Lordship, then kindly give me a liberty to file another affidavit, another writ petition, Lordship.
Mr. B. Kaklari, Learned Counsel appearing for the petitioner submits that during the pendency of the writ petition, his client has been promoted. Therefore, the prayer in the writ petition has become redundant. Although the petitioner has apprehension about the fixation of date of seniority, Mr. Kaklari seeks leave of this court to withdraw the writ petition with liberty to file again as and when a proper cause of action arises. Mr. I. Vatakul and his standing counsel for
All the respondents, my lord.
PHE department.
Excise.
Excise department appearing for the respondents is present and does not have any objection to the said prayer. In view of the above, this writ petition stands disposed of on withdrawal with liberty as prayed for. Consequently, IA number so and so also stands disposed of.
Demobilize,
Aye,
Lordship.
Acha, IA and the IA party. Yes, any other matter? All right. What,